than failure in conflict.
Mother of the appellant died, my lord, on 25th. Yesterday I have served a copy to Mr. Parthasarthi for interim.
Oh, please for lunch for a copy. And asked him to obtain that in.
My lord, yesterday I have already supplied this.
Special notice to us. Yeah.
Tell that special notice.
My
has
lord,
to
my-
be the-
Yeah.
Your Lordship, item 18 from today's list. Mr. Parija is leading in this matter on behalf of the Revensa University. I have already taken consent from the petitioner to take adjournment, Your Lordship. Any date, Your Lordship, in November 10th or 13th?
Yes.
Your Lordship,
18.
18. Readings are already completed.
It's a writ appeal.
Your Lordship.
And Mr. Mishra and his senior advocate is.
Your Lordship, Mr. Ratha, who is the counsel in this case, we have already taken his consent.
But Kali Prasanna Mishra name is there in.
Lordship, I believe he is not appearing anymore.
What do you want?
Adjournment, Your Lordship. Any date, November
Have
10th.
you intimated Mr.
Yes,
Bhatta?
sir. Your Lordship.
Yes, sir. So you both of you tell the one. 10.
Your Lordship.
All right. A mention is made on behalf of Mr. Ashok Parijana,
Your Lordship.
and senior advocate, who is supposed to argue the matter on behalf of the respondents number. Respondent number.
One, Your Lordship. Revensa University.
Acha. Respondent number 1.
Your Lordship.
Respondent number 1 is no, it is 2.
Two.
Revensa University is 2.
I'm extremely sorry.
2 and 3 are the Revensa University.
Yeah.
2 and 3. Submits that he has some difficulty today.
Your Lordship.
So Parija has some personal difficulty today, and the matter will be taken off. We commencing from 10th November 2025. Mr. Sridhar Ratland Council appearing for the appellant has no objection to such prayer for adjournment. On consensus of both the parties, list this matter on 10th of November 2020.
God bless.
Any interim order is there to continue or not?
No, Your Lordship.
No.
They are there.
Supplemental list, item number 1.
One minute.
Just a minute.
Respondent service କହିଥିଲା appellant କୁ କରିଦେଇଥିଲେ
Applicant have to, I am again send the notice to the respondent to the
5, 6, 7.
IFC group 567.
On hello.
And I am received the overturned that there 3 respondents are died. So I feel it will come Monday, we can file the.
No, the problem is that Honorable Supreme Court, I think they have
My lord.
fixed that it should be disposed of within a particular. Let us see that. You come to the Honorable Supreme Court's order. That is. On behalf of Koti. It says that having heard the learned counsel for the appellant's page 3, it seems that the issue raised herein above are required to be determined by the Yuans of Court Affairs after summoning the relevant record. Such an exercise has not been undertaken with the included order dated sponsor. Consequently, we allow the appeal in part, set aside the order dated sponsor, remit the matter back to the High Court for base adjudication of the writ appeal number sponsor. Since the respondents have not entered appearance before this court, the High Court is requested to issue fresh notice to them and to secure their presence before deciding the matter afresh. It will be appreciated if the subject controversy is decided by the High Court within 6 weeks. You see, the time was given to us 6 weeks and the date of order is orderটা লেখাই যে ডেটটা भी পরে কটি মনে হচ্ছে বলবো অর্ডারটা করা
26 July 2022
আছে
ऊपर भी फॉरवर्ड
and the direction was given that to maintain status quo.
petition की girlfriend
Judicial council is there. February রয়ে গেছে না
now all the three respondents died.
5, 6, 7 and died.
কোনটা অসুবিধা কোন হলো
তারা লিগ্যাল হেয়ার মানে অন্য জায়গায় রହୁଛନ୍ତି
They have to bring LRs on record.
you once you give this information then if they
They
want
may be
to
having,
give-
yes, who is appearing for petitioner?
Your Lordship, I am appearing in item number 1 for the appearance.
So all the three respondents, 5, 6, 7 died. You have to bring LRs up for
Are you sure
LRs on
that-
record.
Yes, my lord. I will file the affidavit and let it come.
They are really
Third, my lord, Monday, I can file the affidavit.
so they are dead
Your Lordship, I'll have to seek instruction with regard to that.
Your-
party
We do not have any
related.
contact as of now with them.
they are all related to each other as it appears petitioner
All of
and
them are related. Isn't it?
your client do not know that
One of the last occasion, my lordship, has that order, the consolidated appeal memo incorporated the substantial legal heir of the appellant. One will.
you see the Kalyani Datta is the daughter of Devendranath Datta,
Right.
right? And this respondent number, who are they? 5, 6, 7?
5, 6, 7.
5 is the son, 6 is the daughter, and 7 is also related. So they are all related.
5, 6, 7, they are appellants. The names that are being
Monday, I can file that affidavit.
Died. All your
I file the affidavit that the notice has, there are 3 persons that died. If,
issued by the petitioner under order.
No, that is correct, but let us be sure that.
Well, keep it on Monday
Yeah,
then, 31st.
we are
File the
keeping it
affidavit.
on
3rd November, Monday, I can file the affidavit.
Your Lordships, if I may, Your Lordship, the names that are falling from Your Lordships, they are appellants. That is Rabindranath Datta, Ministry Mahanti, and Pramod Ranjan
No.
Ray.
Opposite party number, see, where is the consolidated memo?
Your Lordship, the same has already been filed.
Okay, respondent number 5, 6 and 7,
Well,
Your Lordship.
okay, they are different person, not
They are
your.
the 5, 6, 7, they are the Brahmananda Sethi
Acha, all right.
and Maheshwar Naik and
Okay,
Prabhakar Naik.
take down. The Parent Council for the state submitted that in pursuance of the order dated 13/10/2025, the inspector in charge of Gok Police Station proceeded to serve notices on respondents numbers 5, 6 and 7. And he has received oral instruction from the said IAC that all the 3 respondents are dead. However, he 6 times to file an affidavit to that effect. Put up this matter on 3rd of November 2025. Stop. Madam, what is your name?
Shruti Aradhana.
Tuti Aradhana. Shruti Aradhana Mahanti or Shruti Aradhana?
Yes, Shruti Aradhana
Shruti
Mahanti.
Aradhana Mahanti, learned counsel for the petitioner, appellants, present through virtual mode. So it will come and you also take instruction and necessary steps to bring the LR on record of those three respondents. Also, you are saying.
Your Lordship, if the council can be directed to furnish the details of the LRs in their affidavit, we will be
No,
able to.
you are the appellant. Why they will furnish you?
Your
It is your
responsibility.
responsibility. You ask your client and let him, otherwise will pass necessary order on that day. You also indicate on that when the death took place.
My lord.
Okay. Yeah.
I had one meeting, you know, we had applied for the certified copy of the lower court records. However,
Item number 2. Yes, next.
Item 2.
May I please your lordship? My lord, a question has been referred to your lordship, my lord, for a decision, my lord. The question referred is whether the municipality can sue or be sued without being represented by any person. Whether the municipality can sue or be sued without being represented by any person. Your lordship may see your lordship's order dated 2/12/2024, my lord. Order number 9.
The second appeal has been by the appellant challenging the judgment and decree respectively asked by the High Court of Orissa by the matter registered before the land single bench of this court on charge for order written. The matter was directed to be placed with the Honorable Chief Justice for Constitution of the larger bench to answer the following question. Whether the municipal can sue or be sued without being represented by the person. No, copy of the present the land registered registration. So you are appearing for Barampur municipality?
My lord.
What?
Now it is municipal corporation, my lord.
Okay. All right. So why this question arose? What
This
is the-
question arose, my lord, because a money suit was filed against a lessee claiming some payment of arrear due. So in the suit, my lord, a question was framed.
Where is this suit decree?
Which is, my lord, annexure 1. This second appeal, your lordship has the file of second appeal, my lord.
Second appeal the what? LCR of the LCR
Share phase का जाननी है.
judgment होची first additional session ସେଟା ତ money appeal ର
My lord.
ତାର ସେଟା ଆସିଥିଲା ଇଏ number होची MS number 61 of 79
My lord.
ତାର judgment ଟା କୋଡା
Last one.
last one.
This is your lordship, page 6 of the judgment, my lord, where the issues were framed.
No, here the Barampur municipality is the plaintiff.
Barampur municipality was the
Plaintiff.
19.
plaintiff.
Hmm.
The defendant raised an objection saying that this plaint which was presented by municipality, my lord, it was presented on behalf of municipality through the executive officer.
Right.
So a issue was framed that the executive officer is not competent to represent the municipality. Accordingly, a issue was also framed.
Executive
whether
officer is the executive head of the municipal corporation.
He is the executive head, my lord. Because section 9, my lord, says it is incorporated under section 9 of the Municipality Act.
Right.
So it is a statutory body, my lord. So it has to be represented through somebody.
Well, issue what you say,
Page 6, my lord, page 6.
Page 6, para 7.
Para 2.
The issue.
Issue number?
There are 5 issues framed. Which is that issue?
My lord, the
Maintainability.
copy that has been given to me is not legible totally. I
No.
have to collect a copy. Issue are,
Only
paragraph-
paragraph 2 is suit maintainable as laid.
paragraph 7, my lord, para 2 is the suit
Seven.
maintainable as led.
Maintainable general.
Maintainable तो generally general जिनिसटा जो आपण जो specific
That was the pleading before the lower court, that because one of the ground was because the suit was presented
where is
by.
the written statement? Let us see.
No. Next, the
I don't have all the documents, my lord.
findings. First finding.
The issue. Please read out the issue number 2.
Issue number 2, my lord, is the suit maintainable as led?
No.
Finding.
Finding for right of the judgment. It said Mr. B.D. Sharma, the legal counsel for the defendant, submitted that the suit as laid is not maintainable because the executive officer of the plaintiff municipality is not competent to represent the municipality in a civil litigation. This is the issue.
Are you facing any
My
difficulty?
difficulty is that all copies are not readable.
So you take out in your pen drive.
My lord, your lordship may call it next week, my lord. Very recent.
You are Mr. Sahoo.
My lord.
Mr. Ramesh Sahoo, Land Counsel, appearing for Burhanpur Municipal Corporation. The respondent submits that though he has received the copies of the second appeal memo along with other documents, but those are not legible, and he may be permitted to take the what you want actually. The
Your lordship
judgment.
may call it one.
No, what you want, so that will permit you to take in.
I may be permitted to take copies, my lord, through my.
Copies of what you
All, second appeal,
trial court,
trial court order and second
Take the
appeal.
soft copy.
the soft copy of the LCR, which pen drive, registries or permit the Land Council to take the necessary documents in this pen
But
drive.
apart from this legal issue, anything else is surviving in this proceeding? Because you are now a corporation.
My lord,
The situation has already changed.
my,
Does anything survives?
I have to take instruction, my lord.
So otherwise,
You get that. Otherwise, I have to one
Because it is a 30-year-old matter, my lord.
So therefore, we are asking whether anything survives. And in view of the changed circumstances, now you are a corporation.
My lord.
And 8, 9, and all these things will not come in your way. So nothing survives, then academic issue.
Academic issue.
Why should you waste time?
But this is a question your lordship may decide, my lord,
No.
because that will help.
Either.
So far other cases in municipal act is
You
concerned.
don't worry about other case. You think of your problem. If anything survives, then we will go into it. Otherwise, we will just close it saying that nothing
plenty, so
survives.
that is why we ask you to take instruction.
Take
I will
it, sir.
take instruction, my lord.
You can bring it in the on 10th of November 2020.
Lordship may call it on 11th.
No, 11th is a different bench. So we are coming in on 12th of November.
12th, my lord.
On 12th of November 2020. The Land Council for the municipality also, since the municipality is and the plaintiff in this case, plaintiff in the suit, the Land Council for the Mr. Sahoo's question as to whether there is anything servant to be argued in this case. In view of the passage of time, for example.
Item 3.
Corporation.
Whether it survives to be adjudicated. Yes. In the second appeal or not, yes.
May I please, Lordship? May I please, Lordship? Item 3, ma'am.
Yes.
Yes. The company man is seeking a direction from this opposite party bank man to deliver the possession after e-auction entirely deposit the entire amount of 7 crores 16 lakhs and the proceeds and sale certificate has been issued as per Annex
You
one.
are the auction purchaser.
My lord, auction purchaser. Sale proceeds also, sale certificate have issued, Annex 1, my lords. And thereafter, they are not, they will give the
We
possession.
passed the order on 5/4/25.
My lords.
That
That,
Mr. Parida,
yes, sir.
Land Council for the petitioner raised for an adjournment to apprise this court
My lord,
as to when IN number 174024
before the,
filed on so was moved before the
DRT.
DRT,
my lords.
and the present status.
Malus. I've already obtained Malus. Malus can kindly have a
Who
plan.
actually approached the DRT?
That is the respondents Malus, the borrowers Malus,
Borrowed.
Malus.
So what is the status of
Status Malus, I've been Malus, the copies Malus.
the entire order sheet is with you?
Malus, entire order sheet Malus. That's why the Honorable Court directed me to get the entire order sheet. Malus. To be precise, Malus, kindly turn to page 6 of that
1 minute.
copy, page 6, Malus. I have never taken time. It's on page 6.
The SA number is 171 of 2023.
Malus. Directly come to page 6, Malus, for convenience others. And also the last one. London Council for the applicant present, London Council for the respondent number 4 present, London Council for the respondent number 3 present, and submits that the bank may be directed to hand over possession of the property or return his money along with interest. None for the respondent bank. London Council for the respondent number 4 requested time. Request is considered put up on 27/1/25 for hearing. Again, Malus. Again, London Council for the next page, Malus. Present and submits that the applicant is ready with rupees 50 lakhs within 7 days. That London Council for the auction purchase present. Respondent bank must remain present. The date which failing which the necessary orders
And
will be
after the
passed.
bank is taking time.
My lord, bank or either the bank or the respondent, and
Bank.
must be the last order also is that going on taking time, my lord, since 22.
You are also taking time sometimes. The bank, you are for the bank or?
No, I'm for the auction purchase.
Purchase,
my lord.
auction purchase.
Who is for bank? You are,
I have instruction to appear me, no?
either you give the possession or give the money.
Money also that
With interest.
Just now I have got a call that I have to appear, let my management give a copy and I
I'll
will
give-
take.
We
Mr.
can
Zaki-
take up,
I'll give
take up this matter on Friday.
My lord, my lord.
Look, the Mr. Parida, Land Council appearing for the petitioner, has filed the order sheet of the ERT Cutter in essay number 171 of the 2023, which is taken on record. Mr. Swans for Land Council submit that he has instruction to appear for the Union Bank of India, and he may be served with a copy of the writ petition. Let the copy of the writ petition along with all the annexures be served on the Land Council for the bank. Put up this matter on 31st of October 2025, indicating the name of the Land Council in the cause list. And we also shall file the Wakalafnama in the meantime. Stop. Yes, next.
even I filed it, IA also because that also not being considered.
It's all right. So you will either pay the money or.
My lord. Obliged.
Item 4.
Lordship, I am for the rest.
Mr. Das? Somebody is appearing or what? In the,
Lordship, my name is Tushar Ranjan Mohanty.
you are item number 4, you are for the opposite party or what?
No, I'm for the appellant.
No, you are for the appellant.
Yes,
but, petitioner. Somebody is appearing for.
By 23/6 order, my lord.
Respondent number 4. Hey, you are appearing, Mr. Mohanty, you are appearing for? Unmute yourself.
This against the order of the
Yes,
Central
Lordship.
Administrative
Sorry.
Tribunal.
Yes, somebody. is
You are appearing for?
I was the petition applicant. I am for the respondent Deepak Pandit, your Lordship.
Deepak Ranjan.
Deepak Ranjan Pandit. So you have,
Deepak Pandit.
just a minute. we have not issued notice as yet to
No.
the opposite party, but the
The
Learning Council
notice has not been
have you filed your wakalatnama, Mr. Mahanti?
No, your lordship. I just came to know because I appeared. There was a contempt matter.
Oh, you have instruction
Lordship.
to
No, I have
appear
not, your
for-
lordship, because last week there was a contempt. Yes, your lordship. I have instructions to appear.
Okay, so we are asking Mr. Das, he has to serve a copy of the writ petition.
Lordship,
Or are you
I
having
have-
the copy of the writ petition with you?
I have a copy, but it's not very legible. But the
Okay.
point, your lordship, is that in
So,
that area,
whom he will serve the copy? Tell us. Somebody
Your
has to
Lordship.
come to Mr. The Das, the London senior advocate, and to receive the copy. So,
Lordship, I'll send my email ID to them, your lordship. Actually, Mr. Padi, Deputy Solicitor General's office had sent me a copy of the writ petition. I requested them on the last occasion on 23rd, but that's not very legible. They have my number.
okay, that formalities will be done by tomorrow itself, but you file your wakalatnama and
Lordship.
we are taking up this matter next week.
Lordship, can it be on a fixed date, your lordship? Then I'll try to come physically and
Yes,
appear.
all I will take up on 10th of November 2025.
Lordship, can it be 17th? 10th I'm in Calcutta, can it be 17th, my lords?
Okay.
Are you coming physically, Mr. Mahanti?
I'll come physically, your lordship. I'll come physically.
Mr. Tushar Mahanti.
They have filed a contempt. They are moving the contempt, madam. Last occasion,
Mr. Mahanti, some contempt petition you have filed before the CAT and you are pressing for that.
no, last occasion we have stated that the case has been
Yes,
posted to
Lord.
Then
29th.
came to know. about it.
29th, and court has fined 20,000 rupees cost, my lord, knowing fully well that matter has been adjourned to 29th.
Lordship,
Since we are posting this case as per your request on
Lordship.
17th of November 2025, don't press till that
Lordship,
day.
the contempt petition is coming up on 11th of December. So,
Okay.
yeah.
Listen, Mr. Tushar Mahanti, Land Council, submits that he has instruction to appear for the opposite party, and the copy which he has received is not legible. Mr. Das, Land Senior Advocate, appearing for the petitioner, submits that necessary arrangements shall be made to serve a legible copy of the writ petition along with all the annexures on Mr. Mahanti by tomorrow. Mr. Mahanti submits that the matter may be stayed on a week commencing from 17th of November 2025. Mr. Das, Land Senior Advocate, has no objection to such adjournment, but submitted that the opposite party has filed a contempt petition before the London Central Administrative Tribunal and is pressing for the contempt petition, and the Union of India has been imposed a fine of rupees 20,000 on the last date. The Land Council for the opposite party, on the other hand, submits that since the matter is to be listed on 17th of week commencing from 17th of November 2025, and the contempt petition has been posted to which date, Mr. Mahanti?
11th December.
11th December 2025. No order is necessary in respect of that contempt petition. In view of such submissions made by the Land Council for the respective party, place this matter on 17th of November 2025. A copy of the writ petition, legible copy of the writ petition, be served on the Land Council for the opposite party. In the meantime, the Land Council, Mr. Mahanti, shall also file wakalatnama. Yes, next.
Lordship, may it be 17th, your lordship, fixed date, your lordship. I'll come
17th
personally.
will come.
Yeah, lordship, highly obliged. I'll come personally, lordship. It will be my honor for.
Yes, next.
Item 5.
May I please, your lordship? I am for the petitioner. Here I am challenging the order dated 7/2/2025 by the London Central Administrative Tribunal, Kotak Bench, in OA number 260/285 of 2022. The brief fact is,
Just a minute. You have filed the original application.
yes,
Any counter affidavit was filed?
yes,
Have you filed the copy of the counter affidavit? Your annexure 10 is the counter affidavit.
yes, my lord.
Acha. And you have also filed the rejoinder.
Yes,
Okay, now you can proceed. Okay. You are the applicant in the original application.
yes, I'm the
Okay,
applicant.
what was your prayer? Let us come to that way. Original application is annexure 2. Come to that particular paragraph, I8, I think relief sought for. Okay. The lordship may direct the respondent to quash the order dated 35/2020. The annexure 7 passed by respondent number 2 for the ends of justice and direct the respondent to grant non-functional upgradation to the applicant in pay level 9 with grade pay of rupees so and so with effect from so and all the consequential service and financial benefits with area. Okay. So what was observed by the learned tribunal?
They are
Come
observed that
to the operative part. Let us see first paragraph 17. It's running page 33, internal page is 18. Please face it. Impugned order, annexure 1, internal page 18, running page 33. Are you having that copy
Yes,
with you? Or
yes, my lord.
I am not placing?
Are you prepared or not?
Yes, yes, I have
Prepared.
prepared.
Place it.
I have prepared, my lord. Look, para 16, I have just
We
read
are
out.
asking you to place paragraph number 17.
Yes. In view of discussion made above, the decision relied on by the learned counsel for the applicant have no application to present case. Further, since the provision of NFU is clear and unambiguous to the extent that employee on completion of 4 years of regular service in the grade of 4,800 will be entitled to consider by the screening committee for grant of next GP of rupees 5,400 and arbitrarily the applicant had ceased to government servant after his retirement on 31st 12/2017 and NFU become due him on 01/01/2018 as per the decision of Honorable Apex Court. In the case of Subramaniam Supra, this tribunal cannot interpret the provision of and law in the different manner. But my submission is the notional increment and NFU. Both are logically the same. I am here for financial benefit.
No, there is what has been observed here that you can only be considered on completion of 4 years of regular service.
Yes, my lord.
In the grade of pay of rupees 4,800.
Yes.
But perhaps that you did not
Before
complete
completion, you
before
retired.
retired.
I have completed the service 31/12/2017. Then accrue that notification accrue is 1/1/2018. That's the whole fact. So I am claiming that one increment should be given to me because I have completed 4 years of 4 years of regular service.
When?
31st 12/2017, and it is started from 1/1/2014 as a supervisor.
No, that grade of pay of 4,800
Yes.
as has been stated there,
Right.
that is a supervisor.
Yes.
So that is the scale of pay.
Right.
So when you were promoted or whatever in that post of supervisor,
1/1/2014,
1/1/2014.
and have retired 31st 12/2017, and that accrue of that notification is 1/1/2018. One day is the difference, and one increment should be given to me. My plea is one increment should be
Why
given to
that
me.
provision, let us see that 4 years wrong, provision টা, is it been
My lordship,
quoted in
kindly
the order?
come to running page 25.
25, then
Uh, One is entitled to NFU on
কোড পড়ুଛନ୍ତି কোন 25
uh, middle of the para. Middle of the para. The
rule for grant of NFU.
Yes, yes. The rules for grant of
Ah.
NFU provide that one is entitled to NFU on completion of 4 years of regular service in grade of rupees 4,800 according to the applicant since he completed 4 years of regular service in the afternoon of 31/12/2017 and therefore he is entitled to NFU not correct because as per the law. Well, they have stated it is not correct. But my contention is I have completed 4 years of service. I should have get at least one increment. My plea is that. Because the logically it is where for the financial benefit, whether it is NFU or it is national increment.
No, the prayer is for NFU, I think this.
Yes, my lord. My prayer also for NFU.
You got promotion to the pay grade
Yes.
of 4,800 on 1/1/2014.
Yes, my lord.
So 4-year completion.
And I have no any litigation during my service, my lord.
2018 you retired କରିଗଲା 31/2017
That's the problem.
That's it also. Let us see some notice.
Obviously.
This petition has been filed by the petitioner, Petition Rodas,
My name may be mentioned.
with a prayer for quashing the order dated 7/2/2025, passed by the Land and Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 260/00285 of 2022. And with a further prayer also to quash the order dated 30/5/2022, passed by the opposite party number 2, and for a direction to the opposite party to grant non-functional upgradation bracketary NFU in the pay level 9 of pay matrix with grade 2 of rupees 4,500 with effect from 1/1/2016 and all consequential service and financial benefits with arrears and revisions of pension with arrears in terms of the circular dated 8/2/2021. The Land Council for the petitioner submits that the petitioner was the applicant in the before the Land Central Administrative Tribunal, and he sought for the following reliefs. Relief sought for the court for them. And after issuance of notice, the opposite party entered appearance and they filed their counter affidavit. And the petitioner also filed the rejoinder to the counter affidavit. The Land Tribunal has been pleased to hold that since the rule for grant of NFU provides that one is entitled to NFU on completion of 4 years of regular service in the grade of 4,800, and the petitioner has not completed 4 years of regular service in such grade as he retired on 31/12/2017. Therefore, he is not entitled to the for grant of next GP, that is 5,400. The the Land Council for the petitioner submits that,
1114, he was promoted to GP.
who paragraph লেখা হয়েছে?
It is para 2 of the
Paragraph 2 of the,
MP road.
uh,
MP road.
insurance order. Para 2.
2 row, it, para 2, it, V.
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 Acha. It is the case of the petitioner that he got promoted to
Grade B.
what is that GP?
Grade B.
4,800.
A grade pay of
Grade
rupees 4,800 with effect from 1/1/2014 and completed the 4 years on 31/12/2017, the day when he superannuated from his service. And
Says his date of birth is 1/1/1958.
and
Retired.
that the date of birth of the petitioner is 1/1/1958. Therefore, he retired in the afternoon of 31/12/2017.
But for all the purposes,
But
service.
for all the purposes, the service subsisted till 1/1/2018. The it is the contention of the land council for the petitioner that the opposite parties in an illegal manner didn't grant the desired NFU in J level 9 of pay matrix with grade pay of rupees 5,400 to the petitioner, even though the petitioner became eligible for the same. Upon completion of service of 4 years in the post of supervisor. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Mr. Fari, Senior Deputy Solicitor General, submits that he has instruction to appear for all the opposite parties. Mr. Fari. Mr. Pari, you are appearing for all the opposite parties in this case. There are two opposite parties. One, Comptroller and Auditor General of India, number one. Number two, also Principal Accountant General, so and so.
Well, they have a separate panel. Comptroller General were appearing, but the local office they have dealt with.
That Principal Accountant General, Odisha. So either you appear or the notice.
You Lordship may issue notice.
इसके पास अच्छा नाटा दे दूं तो ताले you will serve a copy on them. Mr. Padil and Deputy Solicitor General submit that he will appear for the opposite party number one, and it is stated at the bar that Mr. Swanso used to appear for the opposite party number two. Let a copy of the writ petition be served on the Land Council. Put up this matter, charge of proper of the counter affidavit is filed in the meantime. Yes.
Item 6.
Yes, Mr. Item number 6.
I'm appearing on behalf of Mr. D.K. Mohanty. He is staying on accommodation for the metro.
You are for the
Last week of November.
Last week of November. Okay, So we are adjourning this matter. Mr. Puchayat Land Central Government Council.
Yes, CGC.
And it's present. Are you having power in this case?
No.
Or you are mentioning on behalf of Mr. Akshay Kumar Mahathi?
T.K. Mahathir.
Huh.
Dilip.
What is your name?
Devi Prasad Mahathir.
Devi Prasad Mahathi. So you have no power.
No.
You are an associate of.
Yes.
Please give your name. Mr. Devi Prasad Mahathi, Land Council, appearing for Mr. Akshay Kumar Mahathi, Land Council for the opposite party subjects. That, why you are seeking for adjournment?
It is an accommodation.
Mr. Mahathi is an accommodation, and the matter may be taken up in the last week of November 2025. Mr. Guchayat, Land Central Government Council has no serious objection to such prayer. Is this matter on 24th of November 2025? Yeah.
Item 7.
Well, item 7, the Union of India is the petitioner, and we challenge the order of Land Central Tribunal. Mr. One of my CC is there, they place the matter. Here the case is very narrow campus. What happened after the how the fraudulent activities of the petitioner against whom the inquiry has been made, he has not entered, he has entered in the passbook, but his no entry has been made in the ledger of the postal department and not full the stamp and signature.
You are praying to pass the order dated 2/7/2024 of the
Exactly.
Land Central Administrative Tribunal.
Yes, yes.
Okay, way number so and so. Where is that order?
36.
Annexure 6. And the applicant is the Prabhakar Swai is now the present opposite party.
Yes.
And you have filed the original application. ସବୁଥର କହିବାକୁ ପଡିବ
Original application.
ଆପଣ ଯେତେବେଳେ Union of India is challenging the order, we are repeatedly.
Let's
telling
then
you
urgent, my lord, we will file it.
No, you will file, but why should you not file to begin with?
My
thorough
clerk
civil
here said that he has
to
already
the
filed. I do not know whether this is on the.
We are extremely sorry, my lord, we will file it.
Readings,
Pay something to the bar now.
readings complete ହେଇଛି.
Record ରେ
ଅଭ୍ୟାସ ରହିଯାଇଛି ଆଉ ସେ ଅଭ୍ୟାସ ଛାଡି ପାରୁନାହାନ୍ତି।
ପୁରୁଣା ଅଭ୍ୟାସ ରହିଯାଇଛି।
ବାର ଷ୍ଟାଫ ମାନେ ଯିବେ ବାଲିଯାତ୍ରା ଦେଖିବାକୁ, ତ କିଛି ଡିପୋଜିଟ କରନ୍ତୁ। The Land Council for the Union of India submits that the matter may be taken up in the week commencing from 10th of November 2025, so that we will file the entire pleading. Brought on record the entire pleadings before the Land Central Administrative Tribunal. List this matter on 10th of November 2025.
maybe next week କାହିଁକି ନା ସେଠି ଫିଟବିଟା proceed କରିଯିବ, but tomorrow I will.
ଆପଣ face the blunt now.
When you this writ petition was filed when 16th April 2025. ଆଉ adjournment କେତେ ଥର ନେଇଛନ୍ତି? 1, 2, 3 ଆଜି ହେଉଛି 4 ନମ୍ବର adjournment. And every day ଯେତେବେଳେ ବି ମ୍ୟାଟର ଗୁଡାକ ଟେକନ ହେଉଛି, ଆଇଦର ଆପଣଙ୍କୁ ହଉ ବା ସେ ଅଦର ସାଇଡ୍ କୁ ଆପଣ ମାନେ ଆମେ କହୁଛୁ ଯେ please file the original application, the other entire pleading file. Yes, next.
Item 8.
May I please? In this case, the petitioner challenged the order of the Law Tribunal under Annexure 3, my lord. Order dated 9/5/25, my lord. You will see page 84, my lord. Page 84, my lord.
Just
It may noted that it is talking of the patient also
you
known as.
are for the Union of India. Okay?
Yes, madam.
The prayer was pray that the honorable may be pleased to declare rule that the applicants are entered into the pensionable establishment of railway prior to 1/1/2004 delay in declaration being not attributable to them, they cannot be ousted from the purview of old pension scheme merely because they were regulated under one, so, and accordingly the case to pass the order of delegation. Okay, so the original application was filed, then the other side, means you entered appearance, you filed the counter affidavit also. Huh?
They have filed the count. Yes, in the tribunal, I have filed the counter.
They have put, no?
Yes, annexed through my lord.
Annexed
the
to
counter.
your counter.
Yes, ma'am.
No rejoinder was filed.
Rejoinder was filed, my lord.
Rejoinder was filed.
Fine.
Close करना है.
Rejoinder is not this.
Hmm?
Rejoinder I have not filed, my lord. Only OA application counter.
As well as a consolidated way we have filed that they have not enclosed.
No, no. Are you sure that you have filed the
My lord, I
rejoinder?
have filed.
Rejoinder has filed, my lord.
File करते हैं, दो दिले नहीं कौन पे?
The OA was also mandate.
Monday, my lord, I will file.
OA was also mandate.
No, I have already filed rejoinder in this case.
No,
No, no.
OA was amended. You
Amended.
आप एक जोड़ा फाइल करते हैं, इसे amended वो इटा ना, इसे आगू वो इटा.
Amended ये आज को इटा फाइल कर दीजिए.
हाँ, amended OA भी फाइल करना जाओ.
Paragraph 8 of the writ petition they have
It's
already
all right, all
admitted.
right. It is brought to our notice by the land counsel for the opposite party that the copy of the original application which has been annexed to the writ petition as annexure 1 has been amended subsequently, and an amended OA was filed before the Land Central Administrative Tribunal. And the petitioner, the opposite party, after receiving the counter affidavit, has also filed the rejoinder affidavit, but the same has not been annexed to the writ petition. Land counsel for the petitioner, Union of India, submits that the matter may be taken up next week.
1 week after, my lord.
A week after, so that he will file the amended OA. So also the
Rejoinder
rejoinder
petition.
affidavit filed by the opposite party leaves this matter on 10th of November 2025. Yes.
Item 9.
Item 9, my lord, last occasion, my lord, directed to obtain an instruction that they have filed a petition before the tribunal for implementing the same. So you should not proceed here, but I have no proper instruction received. Lordship may keep it to next week. In the meanwhile, you obtain the instruction and apprise the court accordingly.
My lord,
We are the petitioner. The Union of India is the petitioner.
no, my lord.
Has it been
They are just
compliant?
simply playing with the honorable court's order. Lordship may kindly, last time, my lord, your lordship directed that writ petition will be shopped on me the next day. It was on 11.
13/10/2025.
Therefore, I am not able to
matter.
file the affidavit, but your lordship may kindly see.
No, just come, 13/10/2025 order, are you having that copy?
Yes, my lord.
Please read it out.
My lord, your lordship will kindly see. Matter is taken,
Believe that the caveat petition
yes.
has been numbered as one.
Adil,
so
only
let's
come-
have
Come
that.
to Mr. Ratho, Land Council files a memo from there.
Sit podam.
After
Second
perusing the
page.
order dated 12/9/2025,
No, you read Mr. Ratho,
when you
Land
make the
Council
query,
files a
Mr.
memo.
Paddy, done in DSGI regarding the status of the content petition 59/25, arising out of OA number so and so, which is the subject matter of challenge before this court. The writ petition, it is informed to us. Content petition is now sub judice.
Yes.
Mr. Rathal and the council file a memo wherein the letter dated 10/10/2025 issued by the Assistant Director General, the Chief Postmaster General, Orissa Circle, Bhubaneswar, has been annexed herewith, therein. It has been stated as follow. I am directed to refer to the Orissa Circle letter number so and so dated 19/9/2025, 24/9/2025 on the subject mentioned above, dated 18/12/2024, passed by the Honorable High Court of Orissa with OA number so and so in respect of the applicant only. Strictly without treating it as a precedent in any other similar or connected cases subject to outcome of the writ petition number so and so filed by the department, the High Court of Orissa. Orissa Circle may accordingly file the compliance report before the Honorable CIT tribunal in CP number so and so. Memo along with the letter dated 10/10/2025 is taken on record. Let a copy of this letter dated 10/10/25 be served on Mr. Paddy. Then it, DS, DSJ tomorrow by 30th. Put up this matter on 29. I saw the copy on
just to obtain that instruction on that, and it is your letter.
Well, that content matter was listed yesterday.
Ah.
Instead of complying that order, despite the fact that they had undertaken to comply that
yes,
order,
yes.
now they have filed a petition by saying that these persons are retired persons. Once we pay them, we will not be able to recover that money. Therefore, grant us time, drop the content. But this writ petition was, despite your lordship's order, writ petition was served on me just in last two days back. Therefore, I am not able to file that affidavit. But I have got a memo. Your lordship may kindly see the petition they have filed. And as a result, the Honorable Tribunal, instead of issuing the content, has given them a time to comply the order and ask for the personal appearance of the recipient. Lordship may kindly turn to page, this show cause has been filed yesterday before the tribunal. I will take your lordship to kindly come to page 5, paragraph 7 of that show cause, what they are saying.
This is your content petition.
Page 5,
Additional
paragraph 7.
Complaints affidavit, yes.
7, para 7.
It is for, can I just place it?
Yes, para 7, yes.
Para 7, madam. It is further humbly submitted that since the implementation is subject to outcome of the writ petition and the applicants are now pensioners after retirement from service, it is respectfully submitted that the financial aspect needs to be taken care of very meticulously as to whether the same is to be disbursed to the applicant before disposal of the writ petition or not. And the said aspect is still under consideration as a recovery of any wrongful payment from the pensioners need approval of the Honorable President of India. However, since all the 15 numbers of the applicants of the way have distinct service particulars and the implementation of order needs analysis, verification and calculation of huge financial implication, the same need to be done in a correct manner. Department, the respondents have already complied the order of the Honorable Tribunal and only execution formalities are verified and complied as submitted above. Lordship will kindly turn to the original application. When I filed the original application, by then out of that 15 some odd, except 3 persons, everybody had retired from service. And the recovered amount is known to them. It is not as if it is not, it is a pure.
What happened there?
Thereafter, my lord, the Honorable Tribunal, London Tribunal has passed this order yesterday.
Page 7.
Page 7, my lord.
Yeah, page 1.
At both sides, London Council for the respondent submitted, he has filed additional show cause. Therein, it is stated that the matter is sub judice before the Honorable High Court and the matter is listed on 29/10/2025. It is submitted that the matter was referred to the Postal Directorate, who by the letter dated 10/10/25 has issued instruction to take action for compliance in respect of the applicants only, subject to outcome of the writ petition. It is submitted that since the financial aspects need to be taken care of as to whether the same is disbursed to the applicants before the disposal of writ petition or not, and the said aspect is still under consideration as a recovery of any wrongful payment from the pensioners need approval of the President of India, the same needs to be done in correct manner. The counsel for the applicant submitted that after directions from the Postal Directorate by letter dated 10/10/25, the respondent have to comply the order and then not doing so is willful contempt of the court. 2 weeks time is allowed to the respondent to file full compliance report, failing which the respondent too shall appear before the London Tribunal at 10:30 and the cost of 2,000 shall be paid to them. My lord, at this stage, your lordship may kindly see what were the directorates. Lordship may kindly see the 10/10/2025 letter which they had produced people. Beg pardon? My lord, last time I had filed that one, my lord, along with a memo.
Next. Yes, Mr. Pani.
That 10-10 memo, my lord.
One.
Just a minute. Mr. Pari,
Yes, my lord.
so you are taking adjournment there and your letter has been issued by the Assistant Director General that the relief has to be granted and all these things are there. So why are you not complying the order of the London Tribunal and
All this instruction is not properly instructed to our office, my lord. So I am praying, my lord, let me keep to next week.
No, the problem just see, in one hand, the same
Yes, yes, I understand.
director gives a
Yes.
letter that we will comply.
Yes,
And
I understand, my lordship is
and
absolutely
in
correct.
the contempt jurisdiction, he files an affidavit saying that we will not contempt. What is it?
What is it? We can have a double standard, yes.
Either it comply or we will hear it on merit.
Here, yes, man, merits.
Either of these two. So we will simply assume comply.
They are not giving proper instruction to my associate. That's why today.
Mr. Ratho, Land Council appealed for the opposite party, filed the complaints affidavit filed by the opposite party contender in CP number 59 of 2025 before the Land Central Administrative Tribunal, Cuttack Bench, Cuttack. Also, the order dated 28/10/2025 passed by the Land Central Administrative Tribunal in the aforesaid contempt petition, which has been filed by the opposite party. The Land Council for the opposite party submits that the Assistant Director General P1, Chief Postmaster General Odisha, Bhubaneswar, for the later dated 10/10/25, no?
Yes.
Letter dated 10/10/25 has been issued by the Assistant Director General P1 to the Chief Postal, yes,
CPMG, Odisha Circle.
to the Chief Postmaster General Odisha
Director is
Circle,
from New Delhi, madam. Director is from New Delhi, madam. Secretariat.
Bhubaneswar, wherein which has been quoted in the order dated 13/10/2025 for what he has stated to comply.
To comply.
To comply the order passed by the London Central Administrative Tribunal. But the very same Assistant Director,
Assistant Director.
but the Assistant Director Legal has in the compliance affidavit has stated in paragraph number 7 as follows. Fourth quote, paragraph number 7. Mr. Author submits that it is nothing but a double standard adopted by the opposite parties, by the contender before the Land Central Administrative Tribunal, and now the Land Central Administrative Tribunal has adjourned the contempt petition to 13/11/2025, asking the contender to file the compliance report, failing which the respondent number 2K.
That's CPMG, madam. CPMG.
Failing with
CPMG,
the
madam.
Chief Postmaster General
Postmaster.
Odisha shall appear before the tribunal and a cost of rupees 2,000 shall be paid to the applicants of the original application, who is also the petitioner in the CP. Mr. Pari submits that he has to obtain instruction in the matter and some further time may be granted. Since we have passed no interim order in this matter and the content proceeding is sub judice before the London Central Administrative Tribunal. Date is fixed to 13/11/2025. List this writ petition on 17th of November 2025. It is open to the Central Administrative Tribunal to proceed with the content petition. Yes, next.
Okay.
In accordance with law. Yes, next.
Item 10.
Yeah, in the last decision, your lordship was directed to obtain instructions regarding whether a content petition is filed in this before the London tribunal or not. And I have obtained the instructions that content petition number 58 of 2025 is filed, and there are two dates. One is on 16/9/2025 and another one is on 14/10/2025, and the content petition is adjourned to 18/11/2025.
No, this particular order which you are challenging is dated 11/10/2023. And that was passed in way number 18 of 2019. So against that particular order, which is the content petition?
And the content petition number is
Are you pass on that? Are you at the lecture?
no, the order copy I have now by way of memo I will file.
What is the content petition number?
The content petition number is CP 58 of 2020.
58.
Hand over the copy to the court. Hand over the copy. That copy you hand over.
I'll file by way of memo.
9 memo will 58 of 2025. What is the stage or status of that content petition?
It is to be listed on 18th November 2025.
It has already been listed or not listed ever?
Well, it has been listed for 2 times.
Two times. Now it is posted to 18/11. What order has been passed in that content?
The SOAP affidavit is filed and copy was sought.
So now what do you want?
Really, 1 week adjournment. I think 1 week.
In the meanwhile, the proceeding may be stayed. Whether with contempt they are passing order. So
it is apparent that there was a direction in the improved order to hold the special LDCE examination for the opposite party for promotion to the post of PA within a period of 60 days from the date of receipt of the copy of the order, and such period has already expired since long. Then we have mentioned that when we made a query to the London so as to whether the opposite party has preferred any content petition, so 6.
The order is 11th October 2023. 6 weeks time was granted. You have not complied. In October 2025,
and the problem
after
is
2 years, you are challenging that order. Therefore, we asked whether it has already been complied or any contempt petition is filed or what.
My lord, what
When a
happened
contempt
is,
petition is filed, then you start challenging it.
that's true, my lord. I am not disputing, but thing is this: what happened? This examination part is concerned. It cannot be done independently, individually, because it is an all India test.
It should have been challenged at a particular point, but
Yes.
after the content petition is filed, when you are challenging, that shows that what sort of importance you are giving to the court orders. You are sitting idle to the court orders, and when a contempt petition is filed, you are challenging the order in the High Court in a writ petition. Why will entertain it?
On the ground of laches, you will dismiss it.
Lordship, it gave one chance thereafter.
2 years delay.
The adjournment
Yes.
matter,
There is no limitation for writ petition, doesn't mean that it will not suffer from laches.
pay rupees 10,000 to the one matter we have left today. In this matter, we are directing to 10,000 in the High Court. So that it will be paid to the employees.
May I pray my Lordship, I keep it to next week. In the meanwhile, I will explain. There are the Lordship may pass. Because it is a case, examination cannot be held individually.
No,
If there is given chance.
We are not going to enter into the merits. So it's already delay and the content petition has been filed, not complying the order. Some kind of stand must have been taken in the content petition. But ultimately, after the order has been passed, if there is no stay from this court, then that is to be complied with.
They might be saying that writ petition is pending.
That ground usually taken that writ petition has been filed and it is pending. So not to proceed with the content petition.
Well, they have not examined thoroughly. Lordship may keep to next week. Then price the court authorize. Lordship.
As per the order dated 24/9/2025. The Land Council for the, what is your good name?
Kaivalya Panda.
Mr. Kaivalya Panda, Land Central Government Council, inform this court that for non-compliance of the order dated 11/10/2023, passed by the Land Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 18 of 2019, the opposite party, Bhattakrishna Parida, has already filed a contempt petition before the Land Tribunal, which has been registered as CP number 58 of 2025, which has already suffered 2 adjournment. And in the said contempt petition, Sokas affidavit has been filed by the Union of India, and the matter is posted to 18th of November 2025. Then council submits that you will file the copy of the order passed by the Land Central Administrative Tribunal in the aforesaid CP. This matter on 24th of November 2025. Since no interim order has been passed in this case, it is open to the administrative tribunals, Central Administrative Tribunal, to proceed with the CP number 58 of 2025 in accordance with law. And needless to say that the order impugned is dated 11/10/2023, and the contempt petition was filed before the Land Central Administrative Tribunal by the opposite party, and thereafter this writ petition has been filed
After lapse of 2 years.
after lapse of 2 years. And the adjournment is paid for by the Land Council for the Union of India. And they are not even placing this writ petition, but seeking for an adjournment. Yes, next.
Item 11.
Item 11, we also the petitioner. Which filed it. Mr. Kashyap is there. They filed the caveat.
Let him talk. My lord, this is a case where
No, you are for the
petition
Union of India
petition.
and you have served a copy of the.
Just now, sir.
So you have gone through it.
Yes.
Yes, please praise it.
The petition is challenging the order by NSS 6, that is the order at 9/5/2025, passed by the Honorable Central Administrative Tribunal, wherein it has been directed to promote the petitioner. That is at paragraph 10. During the pendency of the disciplinary proceeding, which has been stayed at the behest of the petitioner by order of the Honorable Central Administrative Tribunal itself on 16/12/2022. Though in the counter affidavit that has been filed in the present case, I verified that the pendency of the disciplinary proceeding order before the tribunal was never brought to the notice of the Honorable Tribunal. However, my contention is the Honorable Tribunal is relied on the judgment of K.V. Janaki Raman case, where at the same time the judgment passed in Harsh Kumar case looks at this, that when there is a delay in the finality of the disciplinary proceeding, which is owing to any act of the petitioner itself, he cannot be benefited by the order of the promotion. My sole contention before the Honorable Tribunal is when the petitioner itself has moved before the Honorable Tribunal and filed a stay petition, and the order was passed, and the order is continuing as such.
Tribunal just come to para 10 of the imperial.
My lord.
Tribunal only says that he is entitled for the consideration.
Yes, my lord.
On 23/1/2021, the disciplinary proceeding started in 2022. So you follow the seal cover procedure. What is wrong in it? What is prejudice to you? Seal cover procedure only.
Yes, to that extent it can be followed, Your Lordship.
That is what the order is.
Yes.
Is it necessary that every order you should challenge?
No, it is not to be challenged, but my lord, the incidents happened in 2020. Internal inquiry committee.
Para 10 of the.
My lord, I obliged. Yes.
What is the problem in complying? It's not prejudicial.
So,
you have to follow seal cover procedure only.
My lord.
Subject to outcome of the department.
Yes.
That's what it is.
If that can be reflected,
Just see, read the order. Please read the order.
That. Yes,
can you please read the order?
In the Instart case, para 10, Your Lordship,
yes.
It is not in dispute that the applicant was entitled to third financial upgradation with effect from 23/1/2021, and charge sheet was issued to the applicant on 27/6/2022. Therefore, the inquiry by the Internal Complaint Committee or contemplation of the disciplinary proceeding is hardly of any matter for adopting the sealed cover procedure in view of the well-pronounced law laid down by the Honorable Apex Court referred above. In the peculiar facts and circumstances of the matter, this bench has no hesitation to hold that keeping the recommendation of the Departmental Assessment Board is contrary to law. As a consequence, we hold that the respondents are under obligation to open the sealed cover and act upon the recommendation of the DAB in respect to the applicant and issue appropriate order within a period of 45 days.
Sealed cover procedure has already been followed?
Yes.
Has it? Are you sure?
No, it is under sealed cover. Procedure has not.
That's what we are asking. Whether it is. Then
no, it is not. It has not been considered. No.
Direction is to open it.
Yes.
Has it been followed? Has it been followed? Sealed cover procedure.
They have followed the sealed cover procedure.
It is for opening.
So this direction is to open it
within 45 days. It is not prejudicial because
once that it is open appropriate order is
appropriate order
say what are the because the proceeding has been stayed at the instance of the so at your instance
where is that order of stay of proceedings?
Proceeding is subsequent to DPC. Screening, kindly see the 3 dates only. Only 3 dates.
That is 23/1/2021.
No, it is 217. Your Lordship may kindly see page 217, 3 dates. Your Lordship may kindly see.
When the DPC held?
DPC held not to the initiation of proceeding, issuance of the charge sheet.
Oh,
that's why Lone Tribunal said. When they are proceeding, that
DPC is over and everything is over.
Everything over. It is name was notified, then proceeding was initiated.
Then
It is not that easy.
how can you initiate follow the seal cover? Seal cover is the proceeding pending, charge sheet already issued.
Yes.
Then you can follow the seal cover.
Yes.
Here, my lord, your lordship is that, therefore I pray, my lord, your lordship may kindly see, take note of 3 dates, my lord. That is page 217, my lord. 217. Last date, 23/1/2021. Your lordship may kindly see.
Yeah.
Page 217, last.
Okay.
Applicant is entitled for third in situ promotion, that was third financial upgradation, with effect from 23rd January 2021 from level 13 to level 14. 25/2022, a letter was issued to all the charges of institutions, centers functioning under the council, requiring the eligible doctors to submit work performance report with supporting documents for those completed 5 years as on 31/3/2021. 25/2022, headquarters forwarded names of the candidates, employees who are eligible, such in
1 minute,
just a
Mr.
minute.
Oja. TDC viceroy. Applicant appear in the chamber. তারপরে দেখি ছ বাইশে রে চার শিট বডি সিঙ্গেল এভরিথিং ইজ ওভার বাই দ্যাট টাইম
যেতেବେଳେ
পেন্ডিং
charge sheet, you come to that Janki Raman case,
Yeah.
which has been quoted in the influence order.
Yes.
that's the main judgment in that scene.
That come to the page number, internal page is 6.
Yeah.
The conclusion part.
Yeah.
Please come to that.
May I please, my lord? Paragraph 4.
Yeah.
The seal cover procedure can be resorted, my lord. That
Where are you reading?
your lordship, internal page 6 of the Learned Tribunal order,
Internal page.
can be resorted only after a charge memo is served on the concerned officer.
তারপরে এই যে তা পূর্বরূপ পড়ন্তু,
Again,
it was then contended on behalf of the authority that conclusions number 1 and 4 of the full bench of the tribunal are inconsistent with each other. Those conclusions are as follows. A conclusion court kale. The data is a conclusion.
yes,
What a conclusion.
consideration for promotion, selection grade crossing the efficiency bar or higher scale of pay cannot be withheld merely on the ground of pendency of a disciplinary or criminal proceeding against an official.
Okay.
The seal cover procedure can be resorted only after a charge memo is served on the concerned official or the charge sheet filed before the criminal court and not before. There is no doubt that there is a seeming contradiction between the two conclusions, but read harmoniously, and that is what the full bench has intended. The two conclusions can be reconciled with each other. The conclusion number 1 should be read to mean that the promotion etc. cannot be withheld merely because some disciplinary criminal proceedings are pending against the employee. To deny the said benefit, they must be at the relevant time pending at the stage when charge memo, charge sheet has already been issued to the employee. Thus, read there is no inconsistency in the two conclusions.
So by the time in this case, the charge sheet was, or the charge was, memo was filed.
27/6/2022.
My lord. Before that, my lord,
And OPC held on
already held, my lord.
30th May 2021.
But the proceeding was not over by then, because the internal complaint committee.
No, this to deny the said benefits, they must be at the relevant time.
Yes.
Pending at the stage when the charge memo or charge sheet has already been submitted.
Charge memo admittedly has not been filed
By that
when
time, yes.
the DPC was held.
Yes.
And so there is the question of adopting this seal cover procedure.
The sole issue is, your lordship, before that the proceeding is initiated, under the offense of sexual harassment.
Even if you have initiated.
Initial complaint committee. Your lordship, I do agree, your
Law
lordship.
says that merely
Yes.
initiation is not sufficient, but
The memo has to be supplied on that.
Right.
Yes. But at the same time, your lordship may kindly see the Horseman's judgment, your lordship is quite aware of.
Is it taken a different view or what?
No, it is that if the delay in finalizing the proceeding, if the proceeding, Janki Raman case stares at me, but as well as.
No, that is the subsequent thing.
That's subsequent stage.
Yes.
It is not applicable. You have
That is
enlisted
not
that
applicable.
Whether
But
the,
the-
you could have adopted the seal cover
Yes.
procedure or not, that's the question.
Yes. That's true.
And the
Before
court
that proceeding,
say,
yes.
say that you could not have because the charge is filed subsequent
Yes.
Right.
to the DPC.
Yes.
But I say only for consideration, my lord, that the incident happened before that. Internal Control Committee
Or
given
maybe
it.
incident-
And the promotion was pending consideration.
No.
It has not been finalized.
Nothing is there. All right, let's take down. The writ petition has been filed by the Union of India challenging the order dated 9/5/2025 passed by the Grand Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number 260 so and so. It appears that the opposite party, Dr. Ashok Kumar Panda, filed the original application with seeking for following reliefs. Quote from paragraph number 8. The
Date of charge report. Annexure 4.
the the petitioners entered appearance, filed their counter affidavit, and have you filed any rejoinder? No?
Yes.
And the petitioner also filed the rejoinder affidavit. The Lennon Tribunal has been pleased to, after considering the pleadings of the parties and hearing the land counsel for the respective parties and taking note of the ratio laid down in the case of Union of India versus KV Janki Raman, that is AIR 1991 page 2010 though?
Yes, sir.
2010 and other citations of the Honorable Supreme Court in the case of Swanshaw has been pleased to hold as follows. Quote paragraph number 10. The main contention raised by the Land Council for the Union of India is that, what is the date chart? That
Annexure 4.
the departmental proceeding which was initiated against the opposite party was stayed by the Land Central Administrative Tribunal. Okay, sir, stay,
16/12/2022. Next 3 years.
Was stayed on by the order dated 16/12/2022. And therefore, since at the instance of the petitioner, at the instance of the opposite party, the proceeding was stayed. Therefore, the Lennon Tribunal should have considered the same and should not have directed the seal cover to be opened and to act upon the recommendation of the DAV in respect of the opposite party and to pass appropriate order within a period of 45 days from the date of receipt of the copy of the order. He has relied upon the decision of the Honorable Supreme Court in the case of
In 2017,
pass on. In case of Swanshaw. Wherein, who paragraph would have
my lord,
in case of Harsh Kumar Sharma versus State of Punjab,
my lord.
reported in Swanshaw, wherein it has been held, who paragraph, he is responsible, then
Yes, Your Lordship. It is
Okay.
Your Lordship, it is paragraph 14, 15.
just a minute, wherein in
It is
paragraph,
referring to the OM of 1992, paragraph 14.
wherein in paragraph number 14, 15, then
14, 15, and the relevant paragraph is paragraph 24.
24.
4, my lord.
Swanshaw, hello? This is the only decision you are.
Lordship.
The Land Council for the opposite party, on the other hand, submitted that the ratio laid down in the said decision is not applicable to the factual scenario. In as much as the the Honorable Supreme Court in the case of KV Janki Raman has laid down the following principle. The quote कर देवे से जो these conclusions are से जो रही to the authority first line like with the authorities to up to the tribunal এটা quote कर देवे है ना. Internal page 6 running page 312 the very first line the authorities to so and so. He further submits that in the case in hand the departmental proceeding
the promotion the process initiated
the process for promotion was initiated on 20
25, 2020.
Was initiated on 25/2025 and
2 million.
25/2022 and
Charge sheet was issued.
charge sheet
27/6/2022.
it was called for applications were called for
and letter was issued and a letter was issued to all in charges of the institute oblique centers functioning under the council requiring the eligible doctors to submit work performance report with supporting documents for those who completed 5 years as on 31/3/2021. And accordingly, the headquarters forwarded the names of the candidates oblique employees who are eligible for promotion for further verification, wherein the name of the opposite party finds place in serial number 6. And a revised eligibility list was circulated, wherein the name of the opposite party finds place as serial number 4, that is dated 35/2022. And the applicant that the opposite party appeared in the interview as per the CCRS order dated 25/2022 on 35/2022. And the charge sheet in question was submitted under Rule 14 of the CCS bracket CCA and a Rules 1965 issued to the petitioner on 27/6/2022. Therefore, in view of the aforesaid ratio laid down by the Honorable Supreme Court in the case of Janki Raman, it is apparent that the sealed cover procedure should not have been resorted to as charge memo has not been served on the opposite party by the time the promotional aspect has been considered by the authorities. Therefore, the Land Tribunal was justified in directing in the operative part of the order to open the sealed cover and to act upon the recommendation of the DAV. After hearing the Land Council for the respective parties and going through the pleadings placed before the Land Tribunal and the ratio laid down in the so and so, and the relevant dates as mentioned above, we are of the view that there is no infirmity or illegality in the impugned order of the Land Tribunal. Accordingly, the writ petition being devoid of merit stands dismissed. Yes, next.
This was
Item 12.
Content petition, yes, Mr.
The content is we have received the instruction.
Yes.
It is mentioned that on verifying the record, it has been accepted that the landowner has been paid the compensation.
Has been paid. Dune.
Paid into documents because bifurcated division has been bifurcated. So the record is not properly added.
Madam, you are appearing for the petitioner.
Yes, Your Lordship, I am appearing for the petition.
And it has been complied with, the instruction has been received by the Land Council for the state. So we are dropping this content proceeding. That is
Uh,
the instruction.
Lordships, the instructions may kindly be provided to us also.
Acha, all right, we are, the instruction will be given to you, the, whatever instruction he has received, we are placing this matter on 10th of November 2025. On that day, we'll close the proceeding, okay?
Lordships may kindly keep it for 7th because a similar content matter is.
All right, let on. The land council for the state has received the written instruction dated so and so, from wherein it has been stated as follows, quote for the entire thing. The land council appearing for the petitioner submit that he may be served with the copy of the aforesaid letter, aforesaid order dated 10/10/2025. In order to obtain instruction, let a copy of the same be supplied by the land council for the state to the land council for the petitioner. Matter will be registered on 7th of November 2025.
Obliged, Lordship.
They're just coming within a minute.
Lordship, for appointment number 4567, I am filing an objection to the limitation today. If your Lordship permits me, I will file it in the counter. I have served the copy to my learned brother.
I received the copy of the comment.
Also served the copy to learned counsel for the estate here.
How much delay?
982 days of delay. Therefore, I am filing an objection.
You are filing here or?
Move file कर दो counter पे.
Counter पे देख रहे
आ
हैं.
गया.
Scanning ही national.
Lordship may only indicate copies of to petitioner and
Yes,
estate
yes, I have
counsel.
received it. Also submits that we have instruction to appear for the opposite parties number. कहाँ पे कोई देखो? कहाँ पे?
Opposite party number 4567 I am appearing.
4, 5, 6 and 7.
To opposite party 3, your Lordship has directed notice to be taken through PS.
The AD has returned.
ଆପଣ ଆପଣଙ୍କ କଥା କୁହନ୍ତୁ ଆପଣ 4, 5, 6, 7 ପାଇଁ वकालतनामा फाइल करू
Again.
You have already filed or you
My lord, already filed objection. I am filing.
He has already entered appearance for so and so 4, 5, 6 lawsuit and he will file the objection to the delay condonation petition during course of the day.
My lord.
The copy of the same has already been served on the learned counsel for the petitioner, right? I would have gone opposite party number
Opposite party number 3, AD has already returned, my lord. That is the noting.
No one is appearing.
IAC copy of some direction is there.
Huh.
Letter was sent, but man is residing somewhere else, they to on board. Now,
No, my
report
lord.
has, again, the notice has sent to there, after service will come some time.
Emergency service है ही नहीं.
It has been served, my lord. Your Lordship may kindly look at the noting. But in the meantime, AD returned from opposite party number 3 after
And he is
personal
not
service.
Resigning the address which has been mentioned.
No, how it was
He returned from upper personal service लगाई.
personal service is it?
Huh? Personal service.
Personal service is it?
It is up to him. Like since the AD has returned from opposite party number 3 after personal service as reported by the office and none has entered appearance, so it is held to be sufficient. None appears for opposite party number 3. List this matter. केबे रखिए आप
Next week.
next week. List this matter on 7th of November 2020.
10th of November, your Lordship.
10th. अच्छा हाँ ठीक है 10th of November 2020.
Obliged.
लिख लीजिए Mr. Umashankar Mishra and part of the position of it.
Item 14.
Yes, Mr. Maharna.
May please, your Lordship.
Even application for dispensation.
But in fact, this matter has been taken up in 17. My lord is pleased to posted this matter on 7/11 for a fresh admission. But my difficulty is that the tribunal is fixing the content petition by posting on 4/11/2000 for popular appearance.
You filed a memo, that is why it was.
Yes, my lord. I'm placing on merit.
Place.
Yes, my lord. But
You have filed the review petition against the judgment of the land single judge.
No, my lord, this is my lord's order has been revoked. My lord's order dated 2/7/2025.
File a review.
My lord. I with respect to submit, my lord, that there is a very limited scope so far as my lord's order judgment is concerned. Only the review in respect of the error apparent in the face of record is to the extent. What is the may paste the fact of the fact to apprise your lordship?
Don't go to the, we have already discussed. You tell in view of the settled position of law
My lord,
regarding the scope of interference in a review petition.
my lord.
You satisfy us that what is the.
What is the error?
My lord, so far as my lord's judgment is regarding that notification of Rule Board, that one, the 32 of 2006 is not restrictively applicable in the present case is concerned. That is bound out, we are bound by your lordship's order. There is no quarrel in that. Your lordship may kindly see page 26 of your lordship's order, para 10. Only we want to point out that the date of commencement of the fixation of pay of the opposite party, that we have mentioned that your lordship may kindly see, may I place para 10, man. the petitioner having challenged this reasoning, arguing that the relevant date for determining the applicable rule for pay fixation is the date of appointment to the working post, not the date of initiation of selection of training. Since the opposite party joined the working post after the issuance of Railway Board 132 of 2006, his pay fix must be governed by the prevailing rules at that point of time. But we are respectively submit your lordship that his pay has been fixed on 22/5/2008, my lord, not when he's during the training period.
When he joined the working post?
Working post, my lord, he's annexed 2 of the.
When he joined, tell us.
During
when he joined, you simply answer it.
My lord,
Working post.
That is 2005.
Then how
That's
do
our
Is the
view.
training?
That is our view.
That is
You may not agree with this view. You go and challenge it wherever you want.
What is the question of review?
Because my lord, so far as your lordship,
might have taken a wrong view.
bow down, my lord.
We might have taken a wrong view. That's a different.
No. That.
But where is the error?
What we, I put to your lordship. So far as your lordship is dealt with regarding the applicable of the.
You read para 10. You tell us where is the error. We say that from the date of joining in the working post, it has to be applicable.
My lord,
According to you, 2005.
That the date of joining to when the pay has been fixed.
That is your interpretation.
My lord, but that has not dealt with, my lord. That your lordship, what?
The Land Tribunal has also
correct
stated,
also. We
and
don't know.
also we that particular
My lord,
2006
that we passed, the tribunal order has been challenged before the, which is
Right,
in the
you may be
favor of-
correct, sir. We are not saying that you are wrong. You may be correct. We may be wrong. But is it the proceeding?
My lord, what?
Proceeding is something else.
Because my
You know
lord,
that.
what specific averment of the writ petition regarding the date of fixation of his pay is the date he's coming to the courts. Your lordship may kindly see. Your lordship,
We are
your
entitled.
lordship,
We are entitled.
Allahabad High Court judgment has your lordship.
Are we not entitled to commit mistake?
Yeah.
My lord, kindly see your lordship's order, para
The
14.
petition has been filed by this
The Allahabad High Court's order, your lordship has been quoted. Where the date of fixes is the date when he pay has been fixed.
The order dated so and so, in the impugned order, we have noted down the factual aspect in paragraph number 3, and the observation of the Land and Central Administrative Tribunal in paragraph number 5. After hearing the parties, we have held as follows. Quote from paragraph number 13 onwards, 13, 14, and 15. The main contention raised by the Land Council for the petitioner is that
Ground C, my lord.
the RB number 132 of 2006 is merely a clarificatory instruction reaffirming the position as held in Railway Board's ruling in a paragraph B relevio, ruling in RB number so and so, है ना? And it does not extend the applicability of 30% of pay element to the appointments through so and so. And the case of the opposite party, Rudra Narayan Mishra, does not fall under the scope of this benefit. Which was not appreciated by the Learned Tribunal in the impugned order dated 16/11/2023. And therefore, the review petition should be entertained. And the order dated 2/7/2025 passed in WPC number so and so be reviewed or recalled. The scope of review has already been dealt by both of us in the case of so and so. In view of the settled position of law, since we do not find any error apparent on the face of record, we are not inclined to entertain this review petition according to the same standard. पूरा set paragraph का lecture जो stand लिखी थी तो पूरा set of court for the with judgments. Yes, next.
Item 15.
Yes, Mr. Sahu.
Below item 15, this matter is the last portion of the order that is in place of 30, that in place of hard, TY was mentioned, that is.
This
Milord, in the noting is that will request.
ये प्रेस करेছেন আপনি কি পিটিশন ফাইল করলেন তো
Milord itself.
Third party or 30 party.
TY D জায়গায় TY করে
the officers pointed out that in the last paragraph of the order dated 27/10/2025, inadvertently, in place of no third party interest shall be created by the opposite party, number 5, it has been mentioned as no party interest shall be created by the opposite party, number 5, and the same may be stopped. Land counsel for the petitioner submits that the same may be corrected. After perusing the order, we direct that in page number 5 of the order dated 27/10/2025, in the last paragraph where the word 30 is mentioned, the same may be corrected as third. Hello? 30 টাকে inverted comma ভিতরে, the same may be corrected as third. Third টাকে out inverted comma করে. The rest part of the order shall remain unaltered. Corrected copy be uploaded in the High Court website. Yes, obliged.
Item 16.
Item 16.
Your Lordships, I'm appearing on behalf of Mishra. Your Lordship, she is on her legs, arguing the matter at length. Lordships may kindly grant an adjournment.
You are appearing for?
On behalf of Mrs. Roth, for respondent 1 to 4, Your Lordships.
Mrs. Roth means, acha, KIT University. So who is for the petitioner?
I am for the appellant, madam.
You want pass it over?
Adjournment, Your Lordships.
Then you tell, both of you tell when will, because the petitioner has engaged the counsel and he was himself placing the matter, and now he has engaged a counsel. The counsel is ready, and so
Matter is unnecessary getting adjourned this
so
year.
it is 2017 matter. So
Lordships, a short adjournment.
no.
This gentleman is coming every day and sitting in the court.
He is coming to the court.
Every day he is sitting in the court. Who is
And he has
Yeah.
prepared, he was arguing the matter also. And why unnecessarily? Have we fixed the date to today or it has just come by way of a memo? No, we directed it to be taken up on 15/9/2025.
Since then, my lord,
So it did not come that day, so.
since then, my lord, it's been on the list for.
It was there in the list.
Please,
My
no,
lord.
continuously.
They are in the list since
Reason
3
for
weeks.
sitting there.
So we'll take up on Monday. Right? List this matter on.
Monday.
International. List this, a mention is made on behalf of Mrs. Pami Rothwell, senior advocate, appearing for Keat University for adjournment of the matter. The petitioner who is appearing in person is present, so also his land counsel. They have opposed for the prayer for adjournment. However, list this matter on 12th of November 2025 in the top of the list, and it is made clear that no further adjournment shall be granted. Yes, next.
Generally, in the name of senior counsel, adjournments are not granted. Senior counsel doesn't hold any brief. If the one senior is not available, you can brief another senior. On the ground of non-availability of senior, adjournments are never sought. Yes.
Item 17.
Okay, kindly see order dated 1/8/2025. One after another orders are passed that is the benefits of ORSP rules 1998. That they are the.
Relating the OSRTC. OSRTC matter, your lordship had noted that.
Because suppose we
1/8/2025.
Your lordship was directed to state the CMD and the finance secretary and the transport secretary, but it was failed.
That part of the
And
your lordship,
they have,
that's why 1/8/25 orders kind of receive. 1/8/25, last but one para. That they agree that the corporation will pay.
Just a minute.
1/8/2025.
25.
Please read out that order.
Yeah.
Are you having that copy?
Yes, ma'am.
No, I'm a packet of.
Okay.
Please place it.
Para 4. Now therefore,
No,
taking into account
taken up.
further development, Mr. Tripathi on council.
When the matter for our.
This matter is taken up through hybrid arrangement. When the matter was taken up for hearing on 6/2/25, this court passed the following order. Hearing Lord Counsel for both the parties, we think it proper that the chairman, managing director, OSRT, principal secretary to government, commerce and transport department, and finance secretary to government of Odisha shall sit together and make an endeavor for amicably resolving the dispute which has arisen between the OSRTC and 16 retired employees of the corporation in whose favor the order has been passed. Pursuant to thereto, Lord Counsel for the respondent number 1 file an additional document, that is the copy of the office order dated 14/5/25 of Commerce and Transport Department, Government of Odisha, which is taken on record. In the aforesaid order dated 14/5/25, it has been decided the following. Therefore, basing upon these facts, this is hereby decided that the applicability of the revision of a scale of pay ORSP Rule 98 with effect from 16/2009 is a decision of the corporation, which is an independent commercial organization as per its financial viability. That since the OSRT has its own resources to meet the financial burden for revision of a pay their employees under ORSP Rules 1998, government shall not be saddled with any financial or legal liabilities on account of revision of a scale of pay of OSRTC employees. In this regard, while accepting the ORSP Rules 98, the OSRC had also made such conditions in the aforesaid pay revision order dated 18 February 2009. That in this regard, government has time and again clarified to the OSRTC that
government shall not extend any financial support for payment of area dues on a revision of a scale of pay and a DI in respect of a OSRTC employee. That the OSRTC employees are not state government employees and hence ORSP rules is not ipso facto applicable to them. And when state government so desires, the ORSP rules are made applicable to them with the terms and conditions as decided by the state government. Now, therefore, in obedience to the order number 28 dated 6/2/2025 of the Honorable High Court, it is unanimously held that arrear payment with required to the ORSP rules 98 can be paid in favor of Sri Rabindra Kumar Sethi and similar 15 other employees. Taking into account the further development, Mr. Tripathi on a counsel appearing for the appellant OSRTC submit that the corporation may be given 4 weeks time so that it is expected that all the arrear dues of the respondents will be clear. As because in the meantime, 96 and all the dues
Now,
have been
yes,
given.
Mr. Tripathi.
My lord, in the meantime, my lord, the area salary 98 rules, they are paid to the regular employee, those employee existing man, working man.
ଆମର ଏଇ 16 ଜଣ କଥା ଆପଣ ଇଆଡେ ସିଆଡେ
ନାଇଁ,
ଯାଆନ୍ତୁ.
ମୁଁ
Very pertinent question we are putting to you
Well,
that we asked you and you submitted that the corporation may be given 4 weeks time so that it is expected that all the area dues of the respondents will be cleared.
well,
Our query to you that since we have adjourned this matter on your statement,
well,
have you cleared all
No,
the
ma'am.
area dues of the respondent?
no, ma'am.
Then why you made a statement?
My
and
lord,
Why have you not?
My humble
complied?
submission, my lord, that in the, those who are employee now
We are
continuing.
not going to, you
Continue.
made a statement in this court that you are, we then issue the contempt.
No, that,
You have, on instruction, you have made a submission
See,
that.
the earlier you said that we will not pay, the government will pay.
again,
Now it is settled
No,
that the government will not
no,
pay, you have to pay.
say difficult.
Thereafter you said that we will
Why
pay.
this person should
No,
suffer?
kindly be able. ମୁଁ ସେଇଟା clarify
No,
କରୁଛି.
clarification is necessary, only payment is necessary.
Madam, ମୁଁ ଗୋଟେ minute kindly be able. Say your lordship has.
What is the financial liability otherwise? 60
ଏଇଟାର
32 lakhs.
32 lakhs.
32 lakhs only.
ନାଇଁ ସେଇ my lord, ସେମାନେ ଦେଇ ଦେଇଛନ୍ତି.
30 crores.
ଗୋଟେ minute.
For your lordship intervention, they filed the calculation
We
that
to
it is
appear
30.
for on your behalf that.
ମୁଁ ଗୋଟେ minute ଖାଲି କହିଦଉଛି ଆପଣ
Check ନେଇକିନା ଆସନ୍ତୁ.
ନାଇଁ, ମୁଁ
Account ସବୁ.
ମୁଁ ଗୋଟେ minute କହିଦଉଛି. ସେମାନେ ଦେଇ ଦେଇଛନ୍ତି ଏକ୍ଜିଷ୍ଟିଂ ଏମ୍ପ୍ଲୟୀ ଯୋଉ ଅଛନ୍ତି ସେମାନଙ୍କୁ
Exist,
ନାଇଁ କହୁଛି ଗୋଟେ minute
we are
ଦେଇଛନ୍ତି
concerned with the.
କିନ୍ତୁ ସେଇଟା ଯୋଉ ଦେଇଛନ୍ତି ସେଇଟା ବୋର୍ଡର ଆପ୍ରୁଭାଲ ନାହିଁ ଫାଇନାନ୍ସ ମାନେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ମଧ୍ୟ ସେଟା
We will not enter into it. You ask your managing director of
ରିଟର୍ନ କରିବାକୁ ସେ ଇଏ କର।
appear on next week with the checks in favor of each of the 16 and they will come here and they will receive their checks here.
We are inviting your client, we will assist you.
ଗୋଟେ one chance madam, one chance I
No,
will
he will
talk.
be here.
Any day next week ରଖନ୍ତୁ ମୁଁ ଗୋଟେ chance ନହେଲେ ସେ that order may be pass ଗୋଟେ one order ନା one date
One chance to comply.
one chance ଗୋଟେ
comply.
ନାଇଁ, ଗୋଟେ date ଦିଅନ୍ତୁ ନହେଲେ ସେଇ next date ରେ
To comply or what?
ହଁ ମୁଁ ଯାହା ସେ complain କରିବି ନହେଲେ ସେଇ order pass ହବ ନା।
We'll pass the order that he will appear here with the
Hello.
checks. Will not,
No,
because you have made a
no,
statement that.
Not a huge amount,
No,
Mr.
No,
Tripathi. You must.
Poor fellows, they will suffer. Why? Their order has been passed, they are in their favor. You are filing the writ appeal and the state government is saying that it is your responsibility.
our response ମୁଁ ଗୋଟେ ଡେଟ୍ ମେଲର କହୁଛି ଫିକ୍ସ କରନ୍ତୁ
ଲେଖନ୍ତୁ।
ଯଦି ନହେବ ସେଇଦିନ your lordship pass that order.
Mr. Amitabh Tripathi, Land Council appearing for the appellants, made a positive statement before this court when the matter was taken up on 1/8/2025, which you have quoted in the order itself, that the corporation may be given 4 weeks time so that it is expected that all the arrear dues of the respondent will be clear. When we put a pertinent question, made a query to the London Council for the petitioner as to whether the arrear dues of the opposite parties respondents have been cleared, the answer was in negative. When we are proposing to pass an order that the managing director of the OSRTC who appear on the next date with the checks issued in favor of the respondents. The Mr. Tripathi seeks for a short adjournment till next week to obtain instruction that when the respondents will get all the area views, put up this matter. Okay, to give it put up this matter on 14th November 2025.
You ain't finished up, Mr. Tripathi. It's not huge amount.
No, it is huge amount.
Acha, this matter along with the order lekha hai ji, you last order with writ appeal number so and so on. Yeah, problem.
Item 19.
Yes, Mr. Mishra.
Wait. 19, sir.
Yes, item number 19.
9. I'm a permission.
Who is for the
I'm
Mr. Das? Yes, sir.
Petitioner. On behalf
No, sir.
Mr. Das,
Yes,
Mr. Das, you are
State
appealing.
financial purpose.
Yes.
Yes. Please come here. Your matter has been taken over.
Sorry.
You're reluctant to appear.
Case of the petitioner is
Pleadings are complete.
pleadings are complete. What are the
Order dated 5/4/2023. 5/4/2023. Also, I filed an
Just a minute. Mr. Bikeda, Land Council has gone through contended that those civil suit has been disposed of, but again the order against that order, RFA number so and so has been filed, which is pending in the court of so and so, and unless the said matter is disposed of, the question of refund does not arise. Wants to obtain instruction in the matter, this court is of the opinion that if the said matter is pending, this court may not issue any direction for refund of, so this is not good. Yes, Mr. Rao.
So what has happened is, I have purchased the property.
No, we just want about the status of that RFA. because
Appeal.
a judicial order is already
That's
there.
pending, Madam.
Huh?
That is pending.
So, how can we take
No,
up
the matter is like
this
this.
matter for final disposal, and obviously it will, there may be a direction for refund of the amount. Since that is the order, and why the RFA of 2018, is there anybody deliberately delaying the matter, that RFA or?
the concerned advocate of the State Finance Corporation, my lord. In fact, we obtained instruction in my affidavit also annexed the instruction of the concerned lawyer, local lawyer. He said that the edition number 1 is not functioning since long. That's why case is not.
Kindly see the prayer in the writ petition. The prayer is directly contingent upon the outcome of that RFA. Directly contingent.
No, that's correct, Madam. My submission will be just, give me 2 minutes, I will just say. I have purchased the property, paid the money. There are no
Just a minute. The matter is sub judice before which court?
additional district judge.
So, the RFA can be taken off by the London District Judge, Balangir.
Yes, my lord.
And dispose of it. We can keep this matter pending and direct, issue it would be judicial order that since, as you say, of course, we are subject to, we'll obtain the instruction from that registry that since when that presiding officer is not there.
Not functioning since long.
No, which court according to you?
ADJ 1.
ADJ 1.
One of which court?
Balangir.
Balangi. Before that ADJ one, this RFIs may.
Yes. That is my instruction because Lordship can see the local lawyer's letter is annexed also in my affidavit.
ଆପଣ ମାନେ ନିଶ୍ଚିତ କି କହିପାରିବେନି ଅବିକା ଆମେ ଡକେଇବୁ ରେଜିଷ୍ଟ୍ରି କୁ ସେମାନେ ସେଠୁ
ନାଇଁ sir.
ଏତିକି ଖାଲି କୁହନ୍ତୁ ସେଟା କାରଣ ଏଠି the submission which was made on 5/4/23 is that RFA was sub judice before the Land and District Judge Balangir.
Sir, it was sir ମୋ affidavit ରେ ଲେଖିଛି ଯେ ADJ ପାଖରେ ଅଛି. But you can see my affidavit.
No, both we can. Acha, we are doing one thing. We are keeping this matter to Monday. We are obtaining instruction that where this RFA is pending. Number one, if that is pending before the ADJ one Balangir, whether the presiding officer is available or not, then we'll pass the order on that day itself. What do you say, Mr. Rao?
That's correct, my lord, but let me just, I would like to appraise what has happened. I have purchased the property, paid the money, and thereafter somebody else has filed a suit. In the suit, I was also made a defendant, and it was directed that the sale in my favor is invalid. Then I only said that let the money which I have deposited pursuant to the purchase, let it be returned to me if at all.
That is the subject matter of that also.
Lekhundu. On when the matter was taken up on 5/4/2023, the following order was passed.
And the problem is,
Upon paragraph number 3, 4, and 5 को quote कर देंगे. Order taken 5/4/20. Mr. B.K. Das, Land Counsel, appearing for the opposite party corporation, submits that though as on 5/4/2023, RFA number 50 of 2018 was sub judice before the Land and District Judge Balangir. Thereafter, it was transferred to the Court of Land and Additional District Judge 1 Balangir. Or first additional included, first additional District Judge Balangir. And since the presiding officer is not available since long, the RFA could not be taken up. This is your instruction, which instruction he has received from the local council, and he has filed.
Annex 3 is the local
and
council.
he has filed an affidavit to that effect in the compliance affidavit, which is annexed to as annexure 3. The letter of the
And Shankar Prasad Mishra.
all right. Let the registry place a note as to whether the aforesaid RFA is pending before the ADJ 1
Lordship, kindly say in which court is it pending, Lordship?
in which court it is pending, and whether and if it is pending in the court of ADJ 1 Balangir as stated by the Land Council for the opposite party, since when the presiding officer is not available. So
You are the purchaser.
I am the purchaser.
Auction purchaser.
And my sale is now settled.
Again, the money he is running after.
No, that's correct. He's suffering also.
And I am suffering from cancer. That's another problem.
Only fund, no,
Correct.
This is very you return the money if you don't want. Why you unnecessary he is litigating? Because of your litigation with the original borrower.
I mean, that's correct. Original, sir, say, if it appeal,
you keep on fighting.
You keep the property.
You pay his money.
The prejudice,
You take instruction.
Also, I will obtain instruction from the my client.
Very unfortunate.
The Mr. Das shall obtain a specific instruction in the meantime as to whether the money deposited by the petitioner Banamali Das as the
Mishra.
auction purchaser can be returned to him by the corporation in the meantime. Yes.
We can dispose it up if you can.
One more Mishra.
Inspection ବି shown ସପ୍ତାହ ଆଣିବେ
One more
Yes, yes.
ସାର୍ ଆଉ ଟିକେ ସାର୍ ମଣ୍ଡେ ଛଡା ଆଉ ଗୋଟେ ଡେଟ୍ ହେଇପାରିବନି ସାର୍
ନାଇଁ ଏତିକି ତ ଆଣିବେ instruction.
Monday ଛଡା ଆଉ କୋଉ date କଣ?
ହଉ ଠିକ ଅଛି
Monday you have problem.
ନାଇଁ ଖାଲି ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଆଣିବା କଥା ଏସବୁ ବିଷୟରେ ଏଣ୍ଡିଂ ପାଖରୁ ତ ସେ ସାର୍ ନାହିଁ ସେଟା ଯାଇଛି ବାହାରୁ
Sixth.
ସିକ୍ସ
Let it be there on sixth.
ଛଅରେ
ସେ ଆଣିପାରିବେନି ପୂର୍ବରୁ ବେଶୀ ଯୋଉଟା।
No, no, he-
ଦିଟା instruction registry ତ supply କରିଦବ that
ବାସ୍,
instruction will but ଏଇ ଯୋଉଟା instruction ତ ଆପଣ ପଇସାଟା ଫେରେଇବା ଯଦି ସେଟା ସେ କହୁଛନ୍ତି ସେ MD decision ନେବେ
କଣଟା difficulties
It's not
ଅଛି ସେଠି
available. We can place it on अच्छा 10th ରେ ଗୋଟେ week ଛାଡି ଦଉ ଦି ତିନି ଦିନ ବି ଛୁଟି ଅଛି the next week ରେ we are fixing it on that.
If you refund everything is over.
Yes. Next.
Item 20.
Take it up 1 week after.
Who is appearing for
State.
number one state is also
Mr. Rao, the pleadings are complete.
Yes, pleadings are
Mr. Rao,
Not
the
with
land
call
counsel
the
for
record.
the land senior advocate appearing for the petitioner submits that the pleadings are complete, but the matter may be taken up on some other day. Mr. Gupta, land and senior panel counsel, CGC, and Central Government Council is present. This matter केबे रखियो आपण दी जन जा कोंतु. We commencing from 17th of November 2020.
publication
Lord, item 21, can it be taken up tomorrow or day after tomorrow?
Day after tomorrow, it will be taken, not tomorrow.
Can it be taken up as one of the few first matters?
No, this
it has been,
all these matters will come. They will come. It is coming and regularly. Nobody is taking it away from the list. It will come day after tomorrow because tomorrow is that bench is also different bench is there. Yes.
Item 26 mailers.
Reconnection
of power supply, electric supply mailer. Taken on Monday mailers. 8 months line nahi.
You are not available on Friday?
Friday available.
Friday तो आसियो ना?
Friday आसियो.
Friday ही आसियो.
All the matters will come on Friday.
But with due apology, may I make a mention of this? Yeah. This item 59 on the lordship's board.
Yes.
That is plus a matter already admitted, and that is for orders for the 364A conviction for life imprisonment. So that matter was on last Monday was 46, then 55, then 65, then today is 59. My humbly pray this matter will be taken up.
Go serially, yes. Yes.
Friday.
See that, yes.
Right at the top.
No, not top, we cannot order it.
And we found to mention lordships item 56.
Please wait, yes, call the matter, sir.
Item 56, your lordship, item 56, your lordship, there is a lordship directed to take instruction, the government to lordships, it is applicant's wife has been died on 24th, your lordships.
We'll first take up this matter. There's been listed. Why this special somebody has died.
mother of the applicant.
Look on. This man is a local man.
Yes, yes, Chhatrapur.
The in the first hour, the Mr. Roy made a mention to list this matter today by a special notice as he had filed an application, interim application for bail as the mother of the appellant has died. Accordingly, we directed the matter to be listed by way of special. The land counsel for the petitioner submitted that the mother of the petitioner expired on 25/10/2025. Performing the obsequious ceremony, the presence of the petitioner is very much necessary. In support of the government taken in the interim application, certificate issued by the Sarpanch of Aryapali Gram Panchayat has been annexed to the interim application. Stop. Land counsel for the state has also produced the written instruction received from IAC Marine Police Station, District Ganjam, wherein it is also stated that the mother of the petitioner has expired on 25/10/2025. The written instruction is taken on record. Considering the submission made by the land counsel for the respective parties, the grounds taken in the interim application, the written instruction received by the land counsel for the state. We are inclined to release the petitioner on interim bail for a period of 20 days from the date of release. Matter will be listed on such and such date. The land counsel for the petitioner shall file the surrender certificate. While on interim bail, the petitioner shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of the interim bail order. Yes.
Copy in course of.
Yes.
Lordship, item 56, Lordship. Wife has been died on 24, Lordship. Lordship
Which
died-
matter?
Item 56, Lordship.
You got a report?
Awesome. $56.
Yes, Lordship.
What is that IN number?
IN number 2911, Lordship.
Wife of appellant number 1,
And sister of.
who is also the sister of appellant number 2.
Yes, Lordship.
You have filed this application for both the appellants.
Both the appellants.
There are two appellants.
Two appellants, Lordship.
Criminal appeal memo दिया था चलो. अच्छा. IN number 2911 of 2025. Plus I person. This interim application has been filed by the appellants for interim bail on the ground that wife of the appellant number 1, Raghav Patra, who is also the sister of the appellant number 2, Santosh Kumar Sahoo, has expired on 24/10/2025. And in order to perform the obsequious ceremony, the presence of the petitioner is necessary. As for the order dated 27/10/2025, the Land Council for the state has produced the written instruction dated 25/10/2025 of IIC Model Police Station Board, which shows that the wife of the appellant number 1 and the sister of the appellant number 2, Srimati Lakshmi Patra, expired on 24/10/2025. The written instruction is taken on record. Same period for the order.
Order may be course of the day, Your Lordship.
Yes, sir.
Your Lordship, order may be course of the day.
Yeah.
Order may be course
Ah,
of
yes,
of the day.
Supplemental list. Item number 1.
Inadvertently, I could not file the IA for sterilization of Fine and Bell. Let the matter come on next week.
No, it's a criminal appeal
Yes.
or life imprisonment.
Yes, yes, life
Fight it afterwards, there is nothing. It is to be formally admitted.
302.
302.
Yes.
Or admit. Call for the trial court record. What is your good name?
Mr. Sahoo.
Mr. Judicial Sahu, yes.
Item 2.
Concerned section A2 RPC sentence arrive for life. Final amount is 10,000. I'll state it.
Order admit call for the trial court record. The interim applications for bail and sterilization of fine to be considered after receipt of the trial court referral, and counsel for the appellant in the meantime shall supply the deposition copies of the witnesses examined in the trial court to the land counsel for the state. Yes, next.
Item 3.
Similar sentence to arrive for 20 years, 376(2)(n).
Convicted under 362N.
And
Just
67A of the.
Here the punishment is 20 years.
20 years.
So it is to, it's a single bench
Single
matter.
bench
Why it has come to the division bench? Only life and death will be decided. There is no life imprisonment, Mr. Nayak?
ସେ 20 ବର୍ଷ ଦେଇଛନ୍ତି ତାପରେ 5 ବର୍ଷ ତାପରେ
No, that
No,
is,
no,
since the punishment imposed by the petitioner.
Consecutively election will be.
Oh, that is not the, but,
Consecutive.
except life and death, in view of the sentence imposed, in view of the sentence imposed on the petitioner, matters be placed before the appropriate bench in court.
କାଲିକି ନ ଆସିଲେ ସେ ପରୀକ୍ଷା ଦେଇପାରିବେନି।
No, that is, we will just pass the order. You make a mention before the Honorable Chief Justice. We will just do it after we rise, we'll just sign it. Next.
Item 4.
This case, my lord, the petitioner was directed to release on interim bail, but he could not avail. Last occasion, the petition was produced through VC. My lord, directed to.
Nobody is interested in their family to take him.
Yes. Support to poor prisoner scheme. Guideline.
Which part of the guideline helps?
My lord,
Which part of this guideline will help you?
not applicable.
Not applicable.
Only fine play.
Hmm?
Fine the
Fine. What is the solution?
I have requested one of my friend at Ballyuda to meet and arrange it, also taking step.
You know, what is there in this scheme?
Yes,
Suppose, as you know that in the meantime, so far as the under trial prisoners is concerned, that Satyendra until case governs the field. And that says that if he is not in a position to deposit the surety, the cash that amount up to 1 lakh even, 50,000. So that part is there. But that is not related to the convicts. So that is the problem. So here,
This scheme
anything,
is not applicable.
huh?
This scheme is not applicable.
No, we want that, is there any scheme, suppose for some reason or the other, the convicted prisoners जोटा अच्छी, ता पे कौन है election दी? It is on account of non-payment of the fine amount, the superintendent would immediately inform this is not final, would inquire on the financial difficulties so and so. The empowered committee will sanction the release of the fine amount up to 25,000. Fine amount. पर्सनल कॉन्ट्रैक्ट पड़े हुए तो मुश्किल है जो
The hearing paying paperwork already ready.
देखिए पेपर उठा देंगे. Have you received the paper book copy? Case of direct evidence or circumstantial evidence?
Detail जाई नहीं. Detail I have not.
ठीक है. Accused statement was
Direct evidence, the appellant has killed the second wife of the informant as the father. And the son of that lady. Wife of the informant.
We are asking you a pertinent question, whether it is a case of direct evidence or circumstantial evidence. You are having the paper book with you since how many days?
Are you prepared?
Why? Are you doing any charity? You have been interested with the brief.
Today the matter was for the consideration of bail. So
Whatever it may be. For bail, you are not required to go through the evidence. Bail will be granted by just by standing before the court.
no, earlier I was prepared on the date bail was granted. I have submitted your lordship, but today there was your lordship directed to take.
Not that busy a counsel that you cannot go through the paper book.
I beg apology. Let the
For the
matter-
witness.
Huh?
For the witness.
We do before.
The occurrence took place on 22nd day of.
Please read the evidence.
The occurrence took place on the 22nd day of November last year. On the date of occurrence, when I was taking bath in Chua at around 12 noon, the accused dealt 3 blows by the backside of axe to the deceased Mali on her chest, side ear, above, chest and near neck. As such, she fell there. At the time when her son Suraj was running away from there, fell on the ground, after which the accused dealt 2 blows on the back of axe on his left and right head, near ear. After both died, the accused went away.
It's a case of double murder.
Doctor is PW 15.
Yeah. We both, he has conducted PM and injuries are antemortem in nature, sufficient to cause death. Lacerated wound on the left frontal, right parietal region, so and so. double murder. Look, the Learned Council for the state submitted that though the state has formulated a scheme which is called support to the poor prisoner scheme, and the same is dated 3rd of June 2025. But so far as the convicted prisoners are concerned, it only relates to the it relates to release, their release on account of non-payment of fine amount. The scheme, the scheme is, and the scheme is taken on record. Since the appellant has remained in custody for how many years?
For more than 14 years.
More than 14 years. And paper books have been
15 years, 7 months.
15
years, 7 months.
15, more than 15 years. And paper books have been prepared. Matter will be added to the hearing list in the week commencing from 10th of November 2025. Yes, next.
Item 5.
Item 5, my lord, I am for the appellant on behalf of Mr. Samit Kumar Mishra, who is out of town. My lord, as per the noting, the soft copy of the TCR has been sent to digitization section. I may be permitted to collect the copy on behalf of Mr. Samit Kumar Mishra in the section. Paper book already read.
Paper book has been prepared. You must have received the paper book.
My lord, it has. Okay. I'll collect it, my lord.
Last order, it's the copy of the paper book made available to Mr. Samit Kumar. Last order. That is 24/9/2025.
My lord.
How many years he has remained in custody?
Custody certificate not there?
16/12/2018. So it is 6 years. Are you having the copy of the paper book here?
I beg your pardon, my lord. I will collect the copy.
No, you have not received the paper book copy. Paper book you have not received.
Not yet, my lord. I will oblige the order.
Paper book दिया ही नहीं, दिया ही थी. A mention is made on behalf of Mr. Samit Kumar Mishra and senior advocate that paper book has not been received by the land senior advocate. That the copy be handed over to the paper book copy be handed over to the land council. Also appearing on behalf of Mr. Samit Kumar Mishra. Yes, next matter be listed. Pura date देगी उनको.
May I please.
Item 6.
May I please. Initially, case was registered under section that 307 and 376 of IPC, later on down to Lordship 302 and 376, Your Lordship. Custody since near about 12 years, Your Lordship. And Lordship, kindly listen.
Part B.
PW9 was claimed to be an eyewitness, Your Lordship.
With armed remission, it becomes 14 years.
14.
Yes,
And whether your bail application was earlier rejected?
This is first time.
Have you checked up the entire order sheet?
No, no.
Then how you said that for the first time? many appellants are there?
One.
This jail criminal appeal is on the basis of the petition filed by Govinda Hembram.
Yes, sir.
So as it appears, three persons were facing trial: Govinda Hembram, Govinda Murmu, and Baidhar Marandi.
Yes, sir.
So what happened to the other two?
They were acquitted.
They were acquitted. Let us come to the operative part of the judgment.
In this case, Your Lordship,
Both the sworn to established against Govinda Hembram beyond all reasonable doubt, accordingly accused is held guilty. HR failed to establish the charge. Okay. So P02, P76. Rape murder. Paragraph 52. Paragraph 22. Change. On 22, Rachi. The evidence of, yes, please read it out.
The evidence of the prosecution has also been considered and appreciated in the light of the law laid down in the upper study. The prosecutor is an old man of 70 years, and on the date of incident, he was living from Shikharghati Eastern Market during feeding time. On the way near the house of Sudan, it is alleged the accused, who is a young boy of 27 years, forcibly lifted her away, threw her under the bridge, committed rape on her there, and when she left her lap, he accused assaulted her by means
Wait, let me please your logins.
Oh, application.
Sorry, your lordship.
Application moved.
My lord, I filed the IA, it's there on record. IA number 354 of 2025 for bail. And my lord, I'm filing for a stay relation of fine, my lord.
What is the total period he has given?
My lord, more than 15 years. He's in custody since 18/4/2011.
Oh, 18/4/2011, or 1 month. What are the materials from the court?
My lord, there is one witness who's the brother of the appellant and the son of the deceased, who says that he's seen the brother killing the father.
So eyewitnesses have there.
There is one eyewitness, your lordship.
PW?
PW 10, injured eyewitness.
PW?
10.
10.
4 and 12.
Huh?
4 and 12.
My lord, 412 in their cross have categorically, they have come up and stated that no, we have not seen.
4 and 12, though stated in the
Yes,
chief examination that they are eyewitnesses,
but in the cross, they have, it has come out from their mouth.
they have stated what?
PW 4 says that I was sleeping when the incident occurred, and PW 12 says that no, I have not seen. But however, my lord, PW 10 states that I have seen.
And who is the doctor who conducted PM?
My lord, the PM doctor has not been examined in this case.
Then who has proved that PM report?
It has been, my lord would see, but there's a very strange thing, my lord, on the admission of the State Defense Council, the PM report has been accepted. That your lordship will see on the order dated 24/3/2015 of the lower court records.
That is marked as Exhibit 14.
Yes, your lordship.
24?
24/3/2015, page 27 of the LCR.
He was never released on bail during trial.
No, my lord, as I've seen from the records, he was never released.
So, Mr. Pradhan, as it seems that he was never released on bail during trial, and he was taken into custody on 18/4/2011. So it becomes more than 14 years.
15 years, 4 months.
Are the learned counsel for the petitioner, Mr. S. Saurabh, learned counsel for the agitator. When counsel for the petitioner submits that the petitioner is in judicial custody since 18/2011, and as such he has remained in custody for more than 14 years. And so PW4 and PW12 were examined as eyewitnesses to the occurrence, but the cross-examination of those witnesses would show that they are in fact not the eyewitnesses to the occurrence. He further submits that the doctor who conducted post-mortem examination has not been examined. The post-mortem report has been marked as Exhibit 14 on admission. He further submits that since there is no chance of early hearing of the appeal, the bail application may be favorably considered. In this case, paper book has been prepared or not prepared?
No, man.
And no chance of hearing, even paper book has not been prepared. Therefore, there is no chance. Therefore, the bail application may be favorably considered. And counsel for the state, on the other hand, submitted that PW10 is an injured eyewitness, and his version is getting corroboration from the PM report exhibit 14. Considering the submission made by the land council for the respective parties, the period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail. What further you have filed?
Well, today I filed an application for stay relation of fine.
This is an application filed for stay of relation of fine. Let the interim application be registered or there shall be stay of relation of fine. So on so till final disposal of the.
May I pray that the order be communicated directly?
The order be communicated to the superintendent, Biju Patnaik, Open Air Ashram, Jamushari, by the registered judicial, and also a copy we sent to the Land Trial Court. What's that? So yes, next.
Grateful methods.
Item 8.
May I please, Your Lordship? The appellant is charged under section 450, 302, 307 and 324, which has been section 3, the learned court below declared the appellant as innocent under section 324, Your Lordship. There are witnesses and taking into consideration the prosecution with direct witnesses, PW 1 to 5, and with the medical evidence, the appellant has been convicted.
You are in custody since when?
Since 11 year, 9 month, 13 days till date.
You are not on bail during trial.
No, since 15.
You have verified the order sheet of the Land Trial Court.
No, I'm not verified, but
How do you say so? That he was not released on bail during trial. You should verify. Okay, so you mean to say that PWs 1, 2,
5.
3, and 4 and 5.
Your Lordship.
They are the eyewitnesses to the occurrence.
Parents.
Who is the doctor who conducted PM?
PW 6. But here.
What is the weapon of offense used?
Asked. But the same was not produced. That is also disputed by the prosecution. And out of these 5 witnesses, only 3 and 4 have given a statement against the appellant.
Blows you have given?
Your Lordship.
How many blows have been given?
2 blows.
On what part of the body?
One at the neck and the other at the backside of the appellant, of the deceased. PW 6. Your Lordship permit, I would like.
The cause of death was due to hemorrhagic shock due to severe bleeding from so and so much. You are a local man or outsider?
I'm a local.
Belong to
The same village.
Sahoo Hon'Ble, acha. What is that?
11 years, 9 months.
Your Lordship.
Conduct certificate is satisfactory as now. No adverse involvement.
He was arrested by PW 14. There were 2 IO.
11 years, 9 months. So they conduct equation. Or the Land Council for the petition, Land Council for the state. The Land Council for the petition was subject of the petition was taken into judicial custody on 15/1/2014. And as such, he has remained in custody for more than 11 years. And the eyewitnesses are PWs 1 to 5 have stated that it was the petitioner who assaulted the deceased by use of an axe. But the axe has been produced as marked as MO1.
It was marked as MO1, but it was disputed by the witness that the same axe was.
The doctor conducted a postmortem examination. It's PW 6. It submits that the there is no criminal antecedent against the petitioner, and there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Land Council for the state has produced the custody certificate, which indicates that the petitioner custody period is more than 11 years, and he has produced also the jail conduct certificate, which has been given by the Superintendent District Jail Bhawanipatnam, and it indicates to be satisfactory. And he has also produced the written instruction from IAC Narla Police Station to show that there is no other criminal case against the petitioner. The reports produced by the Land Council for the state are taken on record. Considering the submission made by Land Council for the state opposed the prayer for bail, considering the submission made by the Land Council for the respective parties, period of detention of the petitioner in judicial custody for more than 11 years, absence of any chance of early hearing, we are inclined to release the petitioner on bail. Yes. This order be communicated to the sworn source. The rest of judicial place of us, trial court will communicate. Yes, next.
Item 9.
Madam, the present petition of the appellant committed under section 302. Missing of the minor circumstantial evidence, my lord. Was arrested on the 20th August 2007.
The petitioner is a lady.
Lady, my lord.
You have filed an interim application for bail.
No, my lord. A first time, my lord.
28, 2017.
28, 2017.
And Mr. Pradhan, is it a case based on circumstantial evidence?
No, 13 not eyewitness, my lord.
Oh.
Lastly, he said that is when the court passed judgment, the statement.
I know the informants. I also know the accused. They are my co-prisoners. The mother of informant died about 1 hour in our village. On the 12th of October at about 11 a.m., I was there in my house. The accused came to me and gave out that he would feel torture. Then I went to surgery. While she was there.
Surgery is the deceased.
Yes, ma'am.
I went to surgery while she was there in the single field, and I discovered that the accused would kill her. After some time, the accused came there. This is surgery by a casting. She cut hold of top of hair of surgery and placed 3 successive blows and the left side leg of the victim. Surgery fell down with bleeding injuries and died on the spot. Then search for the eldest son of surgery. I could not able to trace him. I was taken the police in this.
Yes, from which line you say that he is not an eyewitness to the occurrence? He is stated to have seen the assault by means of a cutlery, and 3 successive blows were given, and that too on the neck.
Prior to the occurrence, there was a quarrel in between the deceased and the appellant. In the morning at 9 a.m., he said to the PW13 that always he is quarreling with me, today I will kill him. Thereafter, my lord, the occurrence was held, and after him assaulting the deceased, my lord, again he said to the PW13.
On what basis you are taking or you are making a submission that the evidence of PW13 as an eyewitness to the occurrence cannot be believed? That is your submission.
Yes, my lord.
Because in the chief examination, he has not only stated that the appellant disclosed before him to kill, but also dealt axe blows, cutlery blows on the neck of the deceased. And the postmortem report must be also supporting the medical evidence, must be supporting the oral evidence. What have you elicited in the cross examination?
Yes, page number, para number 4, my lord.
Para number 4, Avasam.
Then I stayed in my home. I had not been to the brinjal field. When the appellant assaulted the deceased, he had not been to the brinjal field. That means at time of the occurrence, he was not present there.
Yeah, I had not been to the brinjal field after the death of the deceased.
See,
deceased Morigala Pore Mu se Baigono Kiariku Jai Nai.
Para 3, last 3 line also read. Para 3. Last 3 line. She stayed there for 5 minutes. Then I proceeded to Binjal field of the accused about 11:30 a.m. I stayed there with the deceased for about 30 minutes. Then I returned to the home.
କାରଣ 3ଟା ବ୍ଲୋ ଯେତେବେଳେ ହେଇଯାଇଛି ଇଏ ପଡିଯାଇଛି ଏବଂ ମରିଯାଇଛି ତାପରେ ଇଏ ଫେରି ଆସିଛି ତାପରେ ସିଏ ଆଉ ଯାଇନି ବାଇଗଣ କିଆରିକୁ ଏଇ ଲାଇନଟା ସିଏ କହିଲା paragraph 4 that does not mean that he has never gone to the brinjal field and not seen the occurrence. ବୁଝିଲେ ଆଉ କଣ ବାହାର କରିଛନ୍ତି କୁହନ୍ତୁ?
Page number 52, he also examined 164 was not recorded. Other PW 13.
Who is the doctor who conducted PM?
Doctor, my lord, PW 16, my lord.
PW 13 or PW 16?
Yes. One lacerated injury over left cheek, one lacerated injury below the injury of the another lacerated injury over the left lobe of the injury, number 3.
So how the doctor says that these injuries are possible by Kati? These are all lacerated wounds. Kati କେମିତି ହବ? Sharp cutting. Of course, the doctor has stated that Kati is possible. Para 5 lacerated wounds are possible if a person acts on. I have mentioned from that Kati is sharp cutting with the person assaulted by a sharp cutting weapon, it caused incised wound. I have not noticed hints of blood. It's not a କେତେ ବର୍ଷ ରହିଲେଣି?
8 ବର୍ଷ 2 ମାସ 8 ଦିନ।
ଲେଡିଟା
ନାଇଁ।
ଲେଡିଟା Heard the land counsel for the petitioner, land counsel for the state. The land counsel for the petitioner submits that the petitioner is a lady who is in judicial custody since
28 August
2017. And though the PW13 is an eyewitness to the occurrence and has stated that the appellant assaulted the deceased by means of a kati. But the doctor, PW16, who conducted post-mortem examination, has noticed the lacerated wounds on the person of the deceased. And therefore, the doctor further stated that if a person is assaulted by a sharp cutting weapon, it would cause incised wound. And therefore, the version of the eyewitness, PW13, that the appellant dealt blows by means of a kati is a doubtful feature. It further submits that since there is no chance of early hearing of the appeal in the near future, the bail application of the petitioner may be favorably considered. Land counsel for the state oppose the prayer for bail and place the evidence of P.W. Fadin. He also placed the evidence of stated for whom the seized Kati was produced. And the doctor has stated that the injury sustained by the deceased can be possible by the Kati. Considering the submission made by the land counsel for the respective parties in view of the nature of evidence available on record, while not inclining to release the petitioner on bail on merit, but taking into account our period of detention and judicial custody and the lady case, she is a lady, 3 months bail granted, interim bail. Yes.
Item 10.
May I please your lordship? I am in custody since 15 July 2015. But this is Nirmala Pradhan, my wife. And the eyewitnesses are my daughter, minor daughter, 15 and 16, who are in the custody of my informant, my father-in-law. And both the statement of the 15 and 16 are contrary.
We asked the Land State Council to produce the custody certificate, criminal antecedent, and the conduct of the appellant in jail, and the status of the two daughters who are examined as 15 and 16.
15 and 16.
OPGO why you ran?
Yes. PW 15 has got married in the
Now, Sanma Jiota, Bottoman,
I heard it.
Rochi. And there is no other case pending against the petitioner. Custody certificate kete dekhu ji.
374 is around 10 years.
Around
10 years, 2 months.
10 years.
Okay. More than 10.
ଆଉ ଗୋଟେ କଣ କରିଥିଲୁ ଆଣିବା ପାଇଁ? Jail conduct.
Question is I can see that
No adverse. No adverse school file.
No case is pending.
So that will be certificate given by the jail authority itself.
There is no other case pending.
Pending.
Not written.
And we are not going to see information. Or the land counsel for the petitioner, land counsel for the state. The land counsel for the state has produced the instruction as per the order dated, written instruction, then order dated 28/2025, which shows that the petitioner is in judicial custody for more than 10 years, na?
More than 10.
More than 10 years. And there is no other criminal antecedent against the petition. And the elder daughter of the petitioner was examined in the trial court as PW
15.
15.
She was an eyewitness to the other.
And an eyewitness to the occurrence, has already got married. And the younger daughter of the petitioner, who is also an eyewitness, and examined as PW 16, is staying with her mother. In view of the considering the submission made by the land counsel for the
Her grandmother, your worship. Mother is the deceased here. PW 16 is staying with her grandmother.
Grandmother.
The mother is the deceased here.
Acha. No,
He killed the wife.
Mother's mother-in-law.
Mother-in-law. Grandmother.
Grandmother.
Maternal.
Maternal grand.
Staying with her maternal grandmother. The Land and Council for the state opposed the prayer for bail on the ground that the evidence of the two eyewitnesses, PW and 16, is getting corroboration from the evidence of the doctor, bracketed PW 20, who conducted PM examination.
Yes.
Postmortem examination. Considering the submission made by the Land Council for the respective parties in view of the evidence available on records, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody, we are inclined to release the petitioner on interim bail for 3 months. While on interim bail, the petitioner shall not try to come in contact with with his two daughters. Shall not indulge in any criminal activity, violation of any terms and conditions, and cancellation of the matter be listed on such and such date. Land Council for the petitioner shall produce the surrender certificate. Land Council for the state shall obtain the conduct of the petitioner while on interim bail. It's a jail criminal appeal, so the order is to be communicated to the concerned jail superintendent and also to the district court. These documents are taken on the form. Yes.
Item 11.
Yes, Mr. Sahoo.
She has filed for the custody certificate as well as verification of antecedent.
Dear. On piece तो 2016 में है 9 वर्षों तो है ही नहीं लेकिन नहीं हो रहा है
8 years, 10 months, 23 days.
8 years.
8 years.
ଆଉ କେସ୍ ଫାଇଲ୍ ଅଛି କିଛି
ଆଉ କିଛି ନାହିଁ
ନାହିଁ
No other.
Single murder.
କ୍ଲିୟର କଣ୍ଡକ୍ଟ ଆକାଉଣ୍ଟ ପାଇଁ ଆଣୁନାହାନ୍ତି
Obtained.
ଇନଷ୍ଟ୍ରକ୍ସନ ଫୋନ ପାଇଁ ଦଉନାହାନ୍ତି ଆଇ ୱିଟନେସେସ୍ ଅଛନ୍ତି
Sufficient evidence.
କଣ circumstances
Oral dying
Dying declaration.
exhibit
PW5 and 2 minor.
oral dying declaration PW5 PW5 କଣ କହୁଛି
Husband lordship to
I found Puni was lying in naked condition under so and so. Puni sustained bleeding injuries. I took Puni a trolley rickshaw to the medicine shop of Susan. I purchased medicine, took Puni to our house. On being asked, Puni told me that accused committed rape on her. And by Swan, I noticed abrasion. I guess it's a rape and murder case. Yes, Mr. Panda.
Kindly see, man, the doctor report and
you are what?
For the informed my lord through legal activity. And victim is of only 6 years. That's why victim is of 6 years only. That's why worship has- And informant further informed that only is he has not sent her daughter, minor daughter, to the school. Not going to school due to this incident.
What are the evidence on record?
PW1 is the victim or statement of
My lord,
Okay, one is the victim.
One is a victim.
Sure.
Paragraph 2 would be relevant.
Hmm?
Paragraph 2 of the PW1 would be relevant.
my lord, kindly see the examination report of medical.
At the time of
Applicable
occurrence,
for
he
doctor,
was
my
only
lord.
6 years old. I was dancing in the process of learning food. Mayadhar came and took me toward jungle with him, holding my hand. Thereafter, he gave me some money. He undressed me. Thereafter, he committed rape on me.
How many days the doctor is PW?
PW 14, my lord. Medical report say, my lord, on examination of a victim, there are no body in injury present from the anywhere of the body suggesting of sexual intercourse.
When she was examined?
When was?
She was examined on
After.
18
Next week. Next week, one after.
Let's stop at that. That means the form on side original or a suit.
Hospital certificate.
Petitions so and so. Custody certificate is produced, taken and read copy. Okay. Any criminal antecedent? 302 case. Eyewitnesses there. Have you obtained instruction about the criminal antecedent and jail conduct? Because the custody certificate is available. Which shows that his custody was for 9 years, 10 months. And that was report of February 25 means he has completed 10 years.
10.
Now you have to,
We'll get
he is
the
seeking
jail
for an
conduct and
adjournment. So in the meantime, you produce the learned counsel for the appellant seeks for an adjournment. Learned counsel for the state submits that she will obtain the instruction relating to the criminal antecedent, if any, against the appellant, also his jail conduct. Put of this matter in the week commencing from 17th of November 2025. Yes, next.
Item 14.
Instruction we have in the meantime. Yes, Mr. Patnaik.
May I please your lordship? Plus the present appellants at the custody plus since 2012, 2015. It's 9 years, 10 months, 9 days.
Have you obtained that one? Learned can order to federal and counsel for the state seeks some time to obtain instruction regarding the criminal antecedent, custody certificate and conduct of the petitioners inside the jail custody. That is order dated 18/8/2025. Magician की? Yes, कौन आता?
Two appellants.
Plus two appellants. Nice.
The other appellant, Ms. Ekta Agarwal is appearing. She has been blessed with a child, so she has
No,
sought
we
for.
pick up this matter on
Yes,
other
Miller,
day, but so
therefore.
far as this
Can
Mr.
I bring
Patnaik.
for day after tomorrow?
Next week then also. Huh? Land counsel for the state seeks for an adjournment to obtain instruction as per the order dated 18/8/25. This matter. So then, yes, next. Yes, that one.
Item 15.
अच्छा week लिख देवे jail criminal appeal number 105 of 24. Yes, next.
Item 15. May I please read out?
Custody certificate
Flag 3.
कितने period होची देखिए.
Antecedents.
Already 10 years and 15 days have been.
हाँ,
The
कितने
joint
होची?
session. 10 years, 15
10
days.
years.
Just 10 years is completed 14.
How
Antecedent you are supposed to get. Last order.
25/8
Please produce the instruction. Antecedent. Already put it.
नहीं produce कर दीजिए अंदर. So अगर तो reject है ना. Yes, what is this case? Offense is
302.
302 ये रहा के लिए.
PW8 is the eyewitness.
Just a minute. PW8 है ला eyewitness. Doctor.
PW4 में.
PW4 है ला doctor. अच्छा 8 में पड़े.
The case of double murder.
Double murder.
My lord, this is the false case of false implication.
I do not know the info.
Previously enmity is there.
Please place that in.
Last is PW8. Paragraph 1 also. I know the deceased person, Salyan Dharwa, Ares Suru, and Lalit Verma.
who were also working with me at Bhusana plant Sambalpur. Chelliam Dharwa Suru and Lalit Mitra died about 7 to 8 years back in the morning. On the premises of Bhusana plant. On the date of occurrence, while all of us were sleeping inside the house, the accused came and gave 2 blows by means of an axe, while like iron weapon to Suru and Dharwa. All of a sudden, I got up and shouted at him as to why he was giving blows to Suru by means of the said weapon. But the accused fled away. I rushed outside the room and finding one Bihari aged person who was washing some utensils in front of the nearby room, called him inside the room. The Bihari person came inside the room and told me to call Lalit, who had gone to attend the call of nature. The Bihari aged person went and informed the security guard of the plant regarding the incident. I ran toward nearby field to call Lalit, who had gone to attend the call of nature there. At the field, I saw accused was assaulting Lalit by means of the said weapon of offense on the backside of his head, ear, and other parts of the body. I went near Lalit, who was lying unconscious on the field. Seeing me approaching, the accused already fled away. I immediately returned to the house, and in the meantime, my arrival there, the security guard had already reached there. I informed the matter regarding the assault on only 2 guards.
Inside the room, he given a blow to one. Outside Lalit.
Yes. Cross-examination paragraph 3 would be read. I worked as at Bhusana plant for 6 to 7 years. The deceased has been staying along with me on one quarter since 15 to 20 years prior to the occurrence. I was working as Bhusana plant contractor named Sudarshan. So, man, he corroborates the entire story was here stated in the chief.
My lord,
Yes, of course.
yes, my lord, in the cross innocent, if the occurrence is occurred in a plant, area, in the factory, so there is some the security guard is security checking guard is there. In the cross exercise PW 8 is also stated that my lord 4, para 4. There were 3 rooms adjacent to the case room. The accused was staying in a separate room. There was a previous dispute between the accused and the deceased persons, for which both of them had been shifted to my room. I cannot see the names of the other persons staying in the adjacent room. I cannot say the name of the Bihari old man. I was performing my duty inside the plant premises. The deceased person and accused were also performing their respective duty inside the plant premises. It is a fact that at that time of entry and exit inside the plant, security checkings were conducted. It is a fact that at that time the security personnel verified the gates pass of the employees. It is a fact that while leaving the plant,
Why you are placing all these things?
my lord, there is the some truth. से पहले से accident है कि जाइथिला अलगा जगह जाइके से बाड़ी से मारी
No,
से.
we are not adjudicating the matter of merit. We are just hearing the bail application.
Yes, ma'am.
And the evidence of this eyewitness PW8 indicates that you have committed double murder, and one of the deceased was assaulted inside the room. The other deceased was assaulted outside, and he has seen both the assault and the evidence of the doctor PW4
PW4
also
the manner of
indicates that how both the deceased have sustained 4 wounds. And the doctor has stated that these are
Madam, materials have not been materials have not been examined by the IO. To IO has also stated that not visiting the spot and not chemical examination report has not been received. All these things not properly investigation the case. Already stated the IO, my lord. One statement भी जब हमें देखी हुई सर से भी कोई संशय सोई थी 161 my lord, can I may I say my lord, may be permitted to place the 161 statement of the eyewitness.
It's not necessary. The evidence is there.
सोई देखो से पड़ी जाई थी माने रक्त जुबुडु हुई थी.
Professor, evidence is there. The power of bail application.
We are not supposed to assess the evidence at the stage adjudicating a bail application. So we make any observation that will have some impact at the on the final hearing stage. So therefore, it is not required not necessary also to give any findings on the merits of the case. So if you have remain in custody, it's all like 10 years, let's say. But
Near
it's
about
the
10.
case of,
Near about 10 years.
10 years,
Not
15 days also.
but it's a case
14,
of double
10
murder. So
The
let
case
it
of
be
double
there
murder.
in the list, and we are taking up in January 2016 for June.
But higher had not properly invested, not material exempt, my lord. This ground he is.
January 2016. Next.
16.
Introduction, my lord. I'm in custody since last 17 years, my lord. I was granted interim bail on 3 occasions by your lordships, and I have surrendered. Your lordship had called for the report from the local PS as to my conduct on the last occasion.
केबे जाइथिले interim bail?
My lordship has reflected it in the order dated 3/9/2025.
3/9.
Again, 3/9/2025, your lordship has reflected.
अच्छा, thrice जाइथिले.
Again.
By the way, custody period केते थिला?
Now it is 17 years. On the first occasion, your lordship had dealt with the custody certificate which I had annexed to my IA, which is there on record.
Counsel for the petition and counsel for these two. The land counsel for the petitioner submits that the petitioner has remained in custody for 17 years, and he has been released on interim bail price, that is on 29/7/2024. 29/7/2024 is the order dated. On 3/7/2024, by order dated on 3/7/2024 for a period of 1 month.
My lords.
And order dated 6/11/2024 for a period of 2 months. And order dated 15/4/25 for a period of 3 months, and he surrendered at right time. As for order dated 3/9/2025, the London Council for the State has produced the written report from the IIC Sahib Nagar Police Station, which indicates that the petitioner has not misutilized his liberty while on interim bail. The report is taken on record. Considering the submission made by the London Council for the respective parties, the period of detention of the petitioner in judicial custody, and since the petitioner has not misutilized his liberty while on interim bail, we are inclined to release the petitioner on bail. Yes.
Grateful, my lord.
Item 17.
There are two matters. The other matter, there is
Connected matters. The connected matters are single bench matters, because the conviction is for 10 years. The conviction is for 10 years.
No, 10 years, but it arises out of same trial.
Therefore, it has to be tried by
It should be hard by them.
Yes,
they are on bail.
Okay, next.
Last occasion, as per the paragraph 8, 9, and 10 instruction set forth by from the jail of the Banka.
Yes. Element of the petitioner.
My lord.
कौन है जी?
Both of the eyes seriously affected, for the petitioner unable to see anything in his right eye, and tears are continuously flowing from his left eye.
कौन असला report?
Clinically stable that.
हाँ?
At page 1, further I am to intimate that as per the report of the medical officer dated such and such, health condition started operation convicts is
ଆପଣ
clinically
ଏତେ ବଡ଼ report ଦେଇଛନ୍ତି, କୋଉ report ଟା କୁହନ୍ତୁ?
first page, on
Page
page 10,
first,
ଆଜିର ଯୋଉ report ଟା,
First page ଲେଖା ହେଇଛି,
last para.
I am to intimate that as per the report of the jail medical officer, the health condition is clinically stable.
Report of medical officer, the back side.
You ଆଖି କଥା କଣ କୁହନ୍ତୁ କି according to the convict was admitted in ophthalmology department acha, of PRM so and so for cataract surgery, and was discharged on 35 with the advice of at present the health condition is clinically stable and is under medication. और ठीक ठाक अच्छी कैटरेक्ट ऑपरेशन है और कैटरेक्ट क्या कौन एटा उठा है तो ये आसी ठीक ठाक अच्छी वर्तमान स्टेबल अच्छी और बेल कौन पाएंगे कितने वर्ष रह गए
Sir, about his custody from 23/2015 about
अच्छा अब बेल लागू रिजेक्ट ही चाहिए
During December madhya semane gote utilize करतला गोटे FIR ହେଇଥିଲା
no utilize करतले माने कौन this petitioner how many appellants are there one so he was granted interim bail by this court.
This was
No, my lord, 3 times is granted by from this honorable court and that never misutilized. But on last occasion, my learned friend is taking interest on that. While he is during that, there is a dispute between some things and FIR is lodged and that has been, charge sheet has been given, but that is the instruction of my associate, what my learned friend is. But as per our inspection, he has not committed anything.
देखिए कौन आपको रिपोर्ट को दिया ओ 8 लगा अच्छा चार्ज शीट हैज बीन सबमिटेड अच्छा एटा होची 126 वांस ये घटना केबे हला जो बेल ले थिला बडे इंटरिम बेल ले कौन करथला
जेटा तांको धमका धमकी करथला
126 to 296 115 to 351 to 3
Anyway, you are asking for interim bail. The health condition.
वर्तमान जो कंडीशन ने मागुचंती एटा तो आसुनी ना बाकी आपण सेपरेट फाइल करिवे दैट्स अ डिफरेंट मैटर but at present the purpose for which you are seeking for interim bail we find that the everything is okay that is the report lekho IN number 1467 of 2025 there is an application for interim bail on the ground that the eyes of the petitioner need operation and for such purpose the bail application may be favorably considered. As per the order dated previous orders, the London Council for the State has produced the written instruction from the jail authorities, which indicates that the petitioner has undergone cataract surgery and in PRM Medical College and Hospital, Baripada. And he was discharged and his health condition is now stable and he is under medication. The medical documents have also been annexed to the report which is taken on record. Since in view of such report, we are not inclined to release the petitioner on interim bail. Accordingly, the IS stands dismissed. Yes,
Item 18. May I please, Your Lordships, on behalf of Ms. Nanda? Lord, the appellant is in custody since 18/11/2012. This is a case under section, conviction is under section 376(2)(1) and section 6 POCSO.
देखिए the final report.
appellant is custody since last 10 years. 14/7/10 ରୁ custody ଅଛି. Convicted under section 302 life and
ଆଗରୁ ବେଲ୍ ରିଜେକ୍ଟ କେତେ ଥର ହେଇଛି?
once interim bail rejected on 7/7/2022 ଅଛି. Pre-trial
15/7/2010 କେତେ ଜଣ ଡିସିଜ୍ଡ?
Deceased ଜଣେ
ଜଣେ
minors.
ଆଇ ୱିଟନେସ୍ ଅଛନ୍ତି?
Yes, sir, ଅଛି.
କିଏ?
One eyewitness that is injured, co-injured ଅଛି.
15.
PW 15.
15.
PW 15 is an injured eyewitness,
Minor.
right?
Both were returning the
अच्छा डॉक्टर के PM डॉक्टर
PM doctor ଅଛି.
21.
PW 21 is the doctor.
PM yellow.
अच्छा
Oral declaration ଅଛି.
oral dying declares.
By 18 and 19.
PW 18 and 19.
Minor.
କୋଉଥିରେ ମାରିଲା ପଳେଇ ଆସିଲେ 15 ପଳେଇ ଆସିଲେ।
Gunshot alert.
ହୁଁ
Gunshot injury.
ଏ ଲୋକ କୋଡିଆର
କେନ୍ଦ୍ରାପଡ଼ା ହେଲା.
ସେ ଗ୍ୟାଙ୍ଗ ଲୋକ କି ଏଗୁଡା
Yes,
କଣ?
one of the either alert.
ଆଉ କଣ ଅଛି ତା ଦେହରେ ନା criminal accident? अच्छा put up before some other bench in which one of us Justice SS Mishra is not party. Yes, next.
Item 20.
Let's see, Your Lordship's last order, there was a direction to file a comprehensive affidavit in regard
How
to.
many cases are there against you?
There are 5 cases, Milord.
Oh, what is the affidavit?
That Milord's affidavit I have
filed?
not filed, that I have not been able to file, Milord, that affidavit.
So you want it for the
A
time?
week's time, Milord.
When you will
Ma is bedridden and daughter is
tell us
handicapped.
a date
Wife.
so that we will place this matter on that.
When do you want?
Next week, Milord. Any day next week.
Bring it on 10th, huh?
10th.
We need and serve a copy on the state council, and you are the counsel for the informant.
Yes.
All right. Mr. Das, learning counsel appearing for the appellant, submits that some more time is required for filing the comprehensive affidavit relating to the status of the criminal cases instituted against the petitioner. And the matter may be taken up we commencing from 10th of November 2025. This matter on 12th of November 2025. Comprehensive affidavit we filed in, if any, we filed in the meantime, serving copy on the land council for the state as well as on the land council for the informant. Yes.
Item 21.
Mr. Lenka,
21 means some other, so next week because the file has not come because some.
sure. Non appears for the appellant.
Last date occasion भी আছে.
Huh?
Last date थोड़ी भी है.
Criminal appeal, no appeal kalo.
Next
the matter we na dita week pe jodi appeal korna ta nei jiwa chutti koru January ଆସିବ କଣ?
5/8/24 21/7
5/8/24 non appears ठीक ଆଉ ଗୋଟେ କୋଉଟା?
21/7
21 on the request ଲେଖା ହେଇଛି on the request of the land council for the appellant. You are right, on that day he was not present. अच्छा ତାକୁ ରଖି ଦିଅନ୍ତୁ ନଭେମ୍ବର ଶେଷ ସପ୍ତାହ ରଖିଦିଅନ୍ତୁ 24 ନଭେମ୍ବର 2025. Yes, next.
Item 22.
May I please work? Last time my lord has directed state council, all the active persons have gotten interim bail. During interim, all the active persons have gone on interim bail. During interim bail, whether they have misutilized the liberty granted to them and the custody sector.
Yes.
Last time, state council has produced the custody sector and that the during interim bail, they have not committed anything.
No, you go one by one. प्रथमे से जो M kono Donda
Dandapatra.
Dandapatra. He has been granted interim bail.
Yes, my lord.
By which order?
26/2/24, 26/2/24.
Just a minute. କେତେ ଦିନ ପାଇଁ ଦିଆ ହେଇଥିଲା?
21 days till 13th March 24.
अच्छा, daughter's marriage ground.
Daughter marriage.
And you surrender at right?
Right, absolutely.
Any thing adverse during that period is reported by the IIC? So your bail application on merit was never considered?
No.
Or it was considered, rejected, then you are granted interim bail for a particular purpose?
And on that, my lord, kindly glass to 26/2/24 order.
नहीं सीटा में देख सर लूनी जोटा इंटरिम बिल दिया इतना मेरिट रे अपन को
Merit रे।
पे रिजेक्ट ही चीकी
Merit से दिन first time.
अच्छा really so you can argue the matter on merit what is there देखिए मेरिट रे यदि बेल मूव करना है दी अपन how many deceased persons are here?
One deceased, my lord. M. Dandapatra.
अपन ना पर दंडपत्र
Budupatra.
so just tell me this is Nala
M. Budupatra. Budupatra.
Guru Patra
My lord.
and you are in custody since when? Preparation na nahi?
7/11/2023. 7/11.
2023.
Just a minute. 7/11/2024. 23. Convicted Pachani, custody capital.
Since that.
So you are on bail during trial.
During
They were in the bail.
bail, my lord.
Please, I'm asking him. It is his bail application. Why you are?
7/1/21 to 23/21 on bail. Then 21.
So during trial you are on bail.
Yes, my lord.
Then after the pronouncement of the judgment on 7/11/23 you are taken into custody.
Yes,
ठीक तो?
Yes, my lord.
Is there any eyewitness to the
1, 2, 3 are eyewitness to the offense.
PWs 1, 2 and 3 eyewitnesses. Who is the doctor who conducted PM?
11. PW 11.
Come to the eyewitness evidence. Let us see PW1.
May I please, my lord?
Yeah.
There are two, my lord. The occurrence took place on 17/9/2017 at night. In the evening of Ali's death, there was a gandagol between my deceased younger brother and accused Hari Patra. I was absent during that time. After the gandagol, my younger brother went to our house. During the time of that
Younger brother means deceased.
deceased, my lord.
Yeah.
After the gandagol, my younger brother went to our house. During the time of that disturbance, I was sitting near Mela Mandap. At about 9:30 p.m., the present accused persons, along with three others, namely K. Patra, M. Balakrishna, and K. Soma, came near our house. K. Patra came and called me from Mela Mandap. He also assaulted me there and took me to my house. Then K. Patra asked me to call my younger brother in order to attend a meeting to be held in our Akhada house. Thereafter, my younger brother, M. Budupatra, deceased my lord, came from our house. Accused K. Patra gave a thenga blow on his leg, for which my brother fell down. During that time, all other accused persons assaulted my brother by means of thenga, khonda, muli, paniki, sabot, and thiyakuri. During that time, I, along with my deceased brother and mother, approached accused Bhimo and Kenaya, holding their decks to leave us and not to assault, but they did not listen. During that time, my deceased brother could manage to go inside our house by giving push to the accused persons. Thereafter, all the present accused persons and three others entered inside our house. Though I tried to resist them from entering inside our house, but accused Hari gave me a fist blow, for which I could not resist them, and they all entered inside our house. Inside our house, accused persons Kanaya Patra, Bhima Patra, M. Dandapatra, present petitioner, and M. Balakrishna Patra, assaulted by brother over his head, and other occupants also the means of Tenga, and they brought my brother out of her house and assaulted him. Though my brother requested the accused persons not to assault my brother, but they did not listen, and my mother also sustained injuries over her right hand.
So, yes, all right. So not only outside you assaulted, but when the deceased entered inside to save his life, you also entered and assaulted there. So,
Your name is not taken. Name is not taken.
name?
Names are my chief inside.
Name is taken now. To assaulted. So why bail will be granted on what ground?
Omnibus allegations.
Omnibus allegation. How many blows were given as per the evidence of the doctor? EW11.
11 and 1.
Both lower limb from thigh to foot, upper limb from arm, so and so bandage is cut on. Stitch wound on the right forehead. Stitch wound on the right cheek. Stitch wound on the
So many injuries. So many injuries, yes.
As many as 13 injuries, and those are also multiple. Multiple contusions. So mercilessly, this man has been assaulted. Put up after January 2026.
Interim bail.
Hello.
Interim bail में कर.
Jai Hind, Asile. Please read this matter.
Number 7, my lord.
Friday. Sure.